All rise. Hearing. Go to the field for the state of Michigan now, second. Catherine Day Feeding and presiding honorable
Well, good morning. On behalf of Judges Feeney and Redford, welcome. We have a kind of exceptionally crowded docket today, so we're going to start right in on it and let everybody make whatever arguments they want to make. Our first, if your case involves a minor child, please refer to them by their initials rather than their names. So our first item number today is 14, and it's docket number 376119, People versus Brooklyn Ray Davis.
Good morning, Your Honors. Melissa Freeman on behalf of Ms. Davis. If the facts presented at the preliminary examination in this case are sufficient to establish probable cause for first degree, then the omission theory of second degree is nothing more than surplusage, because then every time a parent willfully fails to provide food and water to a child, that would be first degree. If that's the case, then we're not giving effect to every word in the statute as we need to do. Very clearly, the legislature intended to punish separate categories of conduct in a different way, right? First degree being punished more harshly than second degree. And the government here didn't present any evidence of intent whatsoever. So it was an abuse of discretion for the lower court to find this case over.
Okay. Any questions?
What specifically with respect to Judge Ayub and his analysis, what did you think was the biggest weakness there?
I think, again, not giving effect to the words of the legislature to conclude that because Ms. Davis would have known not feeding her children could cause harm is enough intent, knowing or intentional act.
But it's the intent to not feed the child, right? Because we have a 19-month-old who weighs, I had it written down, but very little. Let's see. I think it was 16 pounds and hadn't really gained much weight. The fluid balance was off, all the rest of those. It could cause permanent brain damage. So the intent to not feed your child, I mean, you're saying, oh, that can only be deemed an omission, right?
Well, with these facts, yeah, I think so, because we don't have any evidence that Ms. Davis did anything additional, right? We have that she willfully failed to provide food, probably. I'll concede that at least for the purposes of the argument, but we don't have any evidence of intent. Like unlike these other cases like Gardner, where we see the kids are getting, beaten and handcuffed in their room and then not fed, or just the other cases where some of the kids are getting fed and one of them isn't because, that kid is being punished for something.
Each time you choose, whether it's for a vulnerable adult or for an infant or young person who's not capable of feeding themselves, every time you walk past them at a state of the day, of the night, that, one could normally expect to be having a meal, and you don't feed them, how is that not an intentional act? You're continuing on your journey. You're acting by not providing food, not providing water.
So, I think that's maybe making a separate argument in part because whether it's an intentional or knowing act, I don't know, the case law has developed such that is an omission enough? And so I think the problem here with this particular facts is that this is the willful failure to provide food. Every time you willfully don't provide your children food, you're accepting the risk that every time you walk past them, they look emaciated and awful, right? And
Right. But if you
So-
do it for such a long period of time that the child is obviously not thriving, and the sibling twin dies, how is that not through a culmination of actions, an intentional act?
I think the problem is that the legislature didn't provide for that, right? They didn't say the willful failure to provide food when it gets so bad that someone dies. It's just simply that that's what the statute says. You need to give effect to every word.
I have a
Ignoring it.
procedural question for you.
Sure.
There are two victims, not in this case number, but the twin of this victim died, right? Has been charged with felony murder, correct?
Correct.
And there's no challenge to that bind over, correct?
So my understanding, I do think it's a bit of a procedural mess. I think some cases.
It looked a little unusual to me.
I'm not trial counsel, but my understanding is that these cases got consolidated, and then there was some confusion. I think sister counsel pointed it out to me about the case numbers that ended up getting put on different pleadings. But my understanding is that the cases got consolidated, and so trial counsel moved to quash the bind over and to dismiss both cases. Because the bind over or the preliminary examination was waived in the female twin case, with the understanding that the evidence presented at the preliminary examination in the male twin, the one who survived, was sufficient or something. So
Right, but if that's been, whatever we do in this case, the defendant is facing felony murder charges based on a first degree child abuse bind over that has not been challenged. Is that correct or incorrect?
no, my understanding is that when the cases were consolidated, both were challenged in the circuit court. There was a motion to dismiss the felony murder case and a simultaneous, but I do think it's a bit messy.
Thank you.
There's nothing further.
When I'm looking at Judge Abe's opinion, it talks about, is he quoting from there? I just want to make sure. He talked about the People versus Maynard case, which is a Michigan Supreme Court from 2004, where the Supreme Court sustained convictions for first-degree child abuse on a theory that the defendant failed to prevent harm with knowledge that serious harm would result. So in People versus Maynard, it was the defendant left her children in the car for over 3 hours on a hot day while she visited the beauty salon. I remember that one. People versus Portellos, where the defendant failed to summon medical assistance despite evidence she knew the child was an immediate threat of death or serious injury. And it was overruled in part on People versus Callaway. But then he goes on to say, in this court's estimation, a clear rule can be synthesized from the Borum case, which was prior to when he talked about those other ones. And more importantly, from that panel's analysis of the child abuse statute as a whole. 1, an affirmative act is not necessary and certain omissions can form the basis of first-degree child abuse where there is evidence that the defendant failed to act with knowledge that serious physical or mental harm will result, and that the specific omissions expressly listed in the statutory definition of omission by themselves cannot sustain a first-degree child abuse conviction. So we can't just say, oh, omission versus act, that you didn't feed, this they did feed, this they beat, that they didn't beat. That seems to be too surface of an analysis, given what I thought was a very well-written opinion by Judge Ayub.
I agree. It was very well written. The problem that we have is that in the facts of this particular case, all we have is at most the willful failure to provide food. When we look at the cases that were cited, like Portellos and Maynard and Borum, well, actually not Borum, but Portellos and Maynard, we have an additional fact that there was an omission and then there was a lie or something else, right? In Portellos, the individual gives birth in the bathroom and then shoves the baby in a plastic bag in a trash can. And that's an act that
But
we
still,
would know would cause harm to a child.
Judge Redford's point, though, it's the not acting with knowledge that serious harm will occur. I mean, one baby died. And then we have this situation with this 19-month-old who has been seriously deprived, I mean, on the verge of brain damage. So it's very difficult to try to say, well, they didn't hit this child, they didn't break any bones of this child, and if they had, it would definitely be first degree, but because they starved this child and knew that the starving of this child would cause imminent and significant harm, brain damage. I mean, the doctor talked about all sorts of things that this child was on the verge of, had they not been able to rehydrate this child and all the other things. So that's, I'm having a hard time with you on that.
Yeah, I agree, except for the fact that the legislature has decided that it's the willful failure to provide food, and it doesn't extend to, but not in cases where severe injury
Right, but you can
occurs, or
do some,
something.
you can do something willfully by not acting.
I
There are,
agree.
it's, there, yeah, so I mean, I understand your analysis. It's a challenging circumstance.
We've had more than one of these cases on this case call. So
Do you think whatever we decide should be published?
I do, because there's a lot of inconsistency, or maybe some cases that have language that could go either way and really needs to be cleared up.
I think you're right. Your colleague representing a defendant yesterday started right out with that, said, we want you to rule our way, but we need you to publish this. And we've all been talking about these cases a lot. So thank you.
Thank you.
Good morning, Audra Blodgett on behalf of the Kent County Prosecutor's Office. My argument is largely outlined in my brief. I will just say, as the overarching theme of my argument, is second degree child abuse is omission, willful failure to provide food. First degree child abuse is willful failure to provide food or any of the omissions, plus an intent to harm or knowledge that a harm will result. So I think that is what distinguishes first and second child abuse. That is what prevents the omission subsection of second degree child abuse from becoming nugatory. And that is what I believe Judge Ayub summarized in his well-written district court opinion. I think that is the first issue before this court, what the law requires. Then the second issue is whether the facts of this case meet the legal requirement. And I outlined the facts before this court in this case at Bindover that we believe do meet the probable cause standard for first degree child abuse. And I'd be happy to take any question.
But can you provide some clarity when Judge Redford was asking about what's happening with the child who died?
Yes, so I reviewed the procedure. I don't think it's extremely complicated. It's just the first degree child abuse was charged against the son who survived. First degree child abuse plus felony murder was charged for the daughter who died. Defendant waived bindover for the daughter. That proceeded to circuit court. They insisted on a preliminary examination for the son, so that preliminary examination was held. Judge Ayub found probable cause. That was bound over to circuit court. Once they were in circuit court, they were consolidated into one case, but there was a motion filed to quash bindover, which I don't believe you can file for one that you waived. So they filed just as to the son. The argument was the same argument distinguishing between first and second child abuse, which just applies to this son's case, and that was denied. So now we're here challenging the bindover for the son who survived. as to first degree child abuse. So I think if this court were to quash or reverse and the bind over is quashed, I think that would just affect the son's case as defendant has agreed to the bind over in the daughter's case.
Thank you.
Just because of the work I used to do. Is there a neglect piece?
I do believe there is a corresponding neglect case, yes.
Okay, no other questions. Thank you. Any rebuttal?
No.
Okay, thank you very much.
Thank
That
you.
case will be submitted. That brings us to item number 15, docket number 367023, People versus Chad Robert Bruning.
Oh, sure. Let's take one side.
Did I tell you the last time we went into court, he left me behind. I couldn't get my robe zipped up. So he and Judge Bazzi come out and they're like, they're waiting for me. I'm like, get my zip. I tell them how you left me behind. I had to get my robe zipped up. That was funny.
Ms. Lewis, I got a note that you're substituting in for Mr. Eggert this morning.
Yes, that's
Okay.
correct.
Well, why don't you state your name just for the record and go right ahead.
Good morning, Your Honors. Jessica Lewis with the State Appellate Defender Office, appearing on behalf of Mr. Chad Bruni. I would like to spend my time this morning addressing the arguments raised by the prosecution in its brief, which, as I explained, are neither supported by the record in this case nor the law. I would also like to save time for rebuttal.
Okay,
Now, as to the first issue regarding the trial court's failure to engage in the plea colloquy process, the prosecution argues that Mr. Bruning failed to raise his right hand, and therefore the court cannot continue.
But that was only after he said, let's see, I guess I'll plead, but I'm not sure. I'm confused. I don't know. I'm scared. I don't understand why I've been charged. I just don't feel comfortable and I don't even know what's going on today. Because I think he said a couple times, I guess I'll plead. Well, I'll plead. But then he talked to his attorneys, and his attorneys, who are very well-known defense attorneys, Norm Miller and Chris Denny, said, we're going to trial. He was like, no. This was the most equivocal that I've ever
Yeah.
seen anybody.
And again, yesterday I talked about it. The Kent County lawyers here, I had the privilege of serving with Judge Feeney on the circuit bench, and I happen to be in the criminal civil division. There's no way you take this guy's plea. It's just, he's equivocal. He is not unconditionally waiving his rights. The trial court asked a number of times. You've had 2 full preliminary hearings, one at a scheduled status conference, a follow-on one. I can't speak for anybody else, but
well, they're not speaking for me because I think he was given approximately 5 minutes to accept a plea and he said, I'll accept it within those 5 minutes.
It was actually 7 minutes. If you look at the transcript.
So he is given 5 minutes to make a decision. When the court does give the 1-minute warning, he does state that I want to plea.
But
And
again, equivocally, I don't know, I guess. That's not a voluntary statement. That's not an unequivocal statement. Plus, this is the 3rd time. This is not like the first time that this has happened.
Whether it's 3 or 30. I mean, this man's looking at life in prison. They don't say, go think it out for 5 minutes in a room by yourself. She gives him 5 minutes and the judge keeps talking about, do you want a jail outfit or a suit or whatever? Everything's going on. He makes a decision. I'll take the plea. It looks like I'm in the minority here.
maybe.
I will agree that he did get some back and forth. However, at some point, he did very unequivocally state that he wanted to accept that plea.
And where was that? Because
It
like
was
I
when
said,
the court was trying to get him to raise his right hand. He does state before that, I wish to plea.
but when he doesn't raise his hand, that's the point at which he says, okay, would you stand, raise your right hand? Him, I just don't feel comfortable. Raise your right hand. Mr. Denny, raise your right hand. Mr. Miller, raise your right hand. Defendant, I don't even know what's going on today. I'm like, deputy, she needs to swear you in. So raise your right hand to the best of your ability. The court, can you raise your right hand as best you can? Mr. Denny, put your hand up. Defendant, I've never. Mr. Denny, well then, we're gonna have to go to trial. The court, time's up anyway, time's up. I know it's not an easy decision to make. And that was at 10:52. And the offer that Mr. Boisvert made was earlier than that. So they gave him actually 7 minutes. But he was asked, I didn't count how many times, but I think he was asked at least 9 times to raise his hand. And you can't swear somebody in if they're not going to raise their hand. And I know that you would be here arguing that we couldn't take his plea because he didn't raise his hand, even if Judge Mims had decided, well, we'll take your plea without you raising your hand.
I don't think that that's correct. This court has stated, particularly in Dunkers v. Kovac, that the hand raising is not actually a necessary part of the oath taking process. Rather, it was only necessary for Mr. Bruning to affirmatively state that he would give truthful statements for the court to continue the plea colloquy process. To the extent that the court believed that he needed to raise his hand, that was an error of law that
Right,
is subject to abuse of discretion.
Whether he raised his hand or he didn't, he is, I am
So if
visualizing the literally 12 years of Monday mornings when I served in this criminal division at the Kent Circuit. And there are hundreds and hundreds of defendants who cannot bring themselves to entering a plea of guilty. That's okay. And that's their right. But we as judicial officers have to confirm that it's a knowing, intelligent, and voluntary relinquishment of rights. The 3 different hearings, 2 previous hearings, and then this one, and you have a jury ready to come in. So we're not, this isn't a status conference. This isn't this is a jury of your peers is going to try this lawsuit and determine one way or the other.
So if I may just add additional context to what was happening. Yes, he was offered the plea prior. However, on the day of trial, the plea offer did change, and it changed in a manner that did directly address Mr. Bruning's prior
it
concerns.
got worse.
No,
Like-
it got better. So
No,
prior to at the
because
final
before-
status conference, Mr. Bruning said that he did not want to accept the plea because he would not be agreeing to 25 years. He would be agreeing to 25 years on top of more. However, the day of trial, what the court offered, or
30-year
what was
tops.
offered was
Yeah.
a 30-year maximum, which again directly addressed Mr. Bruning's concerns. And at that time, after being allowed to talk to counsel in the court about the exact offers of that plea, he then did affirmatively state that he wanted to accept the plea. Now, I will say that the prosecutor does state that Mr. Bruning must have been aware of the plea offer prior to trial. However, I would just point the court to trial counsel statements that they had not actually spoken to Mr. Bruning for months. So it's very likely that that morning was the first time that he had heard that plea offer that, again, did directly address his concern about there being no actual maximum that he was agreeing to for that plea.
But again,
And then
I still can't get beyond his language, his very plain language that he doesn't understand. He doesn't know what's going on. I don't know why I'm here. So even if he said what you claim that he said and what his intent was, the pure language of the transcript belies any voluntariness.
So he clearly understood enough. He was clearly competent enough to undergo or to be subject to trial. So at that point, he is clearly competent and understand enough to be able to also plead. And then I will state that he was not being asked to plead guilty. Rather, the court stated that he had the ability to plead no contest. His counsel, when they were talking about the plea in the beginning, also stated that it would be no contest. And Mr. Bruning stated that it would be no contest. So it was actually not required at any point for him to affirmatively state that he was guilty. And as your honor knows, in the court rules, the court would have been prohibited to get into his participation in the crime, rather it would only have been necessary to establish a basis for finding him guilty for the plea to be accepted.
Sure, but then they would still be able to have to go through and advise him of his rights and the things that he was giving up. And you'd have to talk about the factual basis for the no contest plea and whether everybody was willing to go with that basis. And there's just no indication. His indication is, I don't understand what's going on here. I don't feel comfortable. I mean, those are his words. I'm confused.
And,
I
and
don't know.
nobody
I'm
explained
scared.
it to him, did they, on the record?
And I think this is also where we get into the Sixth Amendment McCoy violation, because at that point, Mr. Bruning again did affirmatively state that he wanted to plea. And at that point, trial counsel had an obligation to carry out his stated objective. They could not, consistent with the Constitution, then state that he wishes to go to trial. Rather, what should have happened, once Mr. Bruning stated that he wanted to plea, and then he expressed some confusion, trial counsel should have asked for a moment to try to clarify whatever confusion there was, but they cannot then go against his stated objective to plea by telling the court that he wanted to go to trial.
Okay, so they said he wanted to go to trial because they took that time out to talk to him. And they came back, and I believe it was Mr. Miller who said, looks like we're going to trial because the jury's waiting to come in. And then he's like, well, wait a second. No. And then he's like, well, but then he starts the whole, I guess I'll plead, but I'm confused. I don't know why I'm here. I'm scared. I don't understand. And then he said he wanted to. So what did Mr. Miller and Mr. Denny do? All right, please raise your hand, Mr. Bruning. Mr. Bruning won't raise his hand. Mr. Miller asks him to raise his hand. So they're participating in the plea, colloquy. Mr. Denny asks him to raise his hand. Mr. Denny asked him to raise his hand multiple times. The deputy, we had the nicest deputies at Kent County Circuit Court. We really do. Even says very nicely, and it must have been loud enough to come on the recording because it says, she needs you to raise your hand so she can, advise you of your rights and swear you in. So even assuming that Mr. Bruning doesn't understand why he needs to raise his hand, right? And everybody tried to help him to do that. And
Isn't he
wasn't doing it.
handcuffed?
Yes.
Yeah,
he
so
is
he's
handcuffed
confused
and-
as,
Right.
raise one hand, raise
And he
two.
does state later that when he was stating that he was confused and didn't understand what was happening, that he actually was talking about the process of raising his hand while handcuffed.
And the transcript, it says that?
Yes, I do not have the exact page number, but later he does come back out after he's asked to change into civilian clothes to try to explain again to the court that he did actually want to plea. However, he was just confused about the hand raising process.
Right, but at
and not
that
what was
point,
going
the
on.
prosecution has withdrawn the plea offer, correct?
They never actually affirmatively state that they are withdrawing the offer.
Well,
They
they said
only
the offer
state,
is good for X period of time plus 2 expired before he was asked to change into civilian clothes, which he has a right to be in when he's being tried in a criminal matter in the state of Michigan. He goes back, he comes in, he says, I want to do it. And it's like, you had the time, it didn't happen, we're proceeding to trial.
so I would disagree. The prosecution stated that you have 5 minutes to make a decision. The court stated you only have 1 minute remaining. And then Mr. Bruning affirmatively states, I wish to plea. At that point, he actually did accept the offer within the allotted time frame.
I
And
challenge
then-
that.
And then assume for a moment that at least one and perhaps 2 members of a reviewing panel believe that whatever he said, his actions are completely inconsistent with a knowing, intelligent, and voluntary waiver of your rights under the Constitution of the State of Michigan of 1963 and the United States Constitution. And so the trial judge is not allowed to take a plea at that point. Assume that that is the analysis, then there's no more offer on the table. He did not accept the offer. And I mean, a trial court has a veneer of 75 people or 45 people on the first floor coming up to the 10th, 11th, or 12th floor of that courthouse and has to try the case. I mean, is a defendant awaiting trial supposed to have 2 hours to get to decide the morning of trial after he's rejected twice? What's the answer, counsel?
Well, he rejected different plea deals. I just want to make that clear. And
Yes.
he is equivocating. I will concede that point. But however, he does reach a point at which he does affirmatively state, I wish to plea. And yes, there is then some confusion for him about the hand raising process. But again, counsel should have clarified with him exactly what was going on, exactly what the confusion was, in order to achieve, again, his stated goal, which he said very clearly, I wish to plead. Counsel should have backed up that
And
objective.
again, I just, I mean, literally, I presided over 6,000 felony cases in 12 years. I presided over 230 jury trials in that time. Of those 230, about 170 are criminal felony matters. I have seen this transpire in front of my very eyes hundreds and hundreds of times. And if a defendant does not voluntarily accept the terms of the plea agreement, if they continue to equivocate, you have a jury ready to go. You probably have 2 to 3 other cases stacked up behind this one. You have to move forward.
So I would say 2 things. We never reached the part where we would have established that the plea was voluntary and knowing, because we never actually reached the plea colloquy process. And I will say,
You began,
What-
the plea colloquy process, counsel, begins when the trial court says, to the best of your ability, raise your right hand so I can administer the oath.
Well, they didn't say to the best. of
I
their
understand
ability.
that. I understand that, my friend. And I'm not saying that the words are perfect on this record, but when it's, I don't know what's going on, I don't understand, I'm confused.
So-
At some point, you move forward.
I fear what's happening here is that we are allowing for Mr. Bruning's ineffective communication style to, by inference, undercut his very clear statement that I wish to plea. We do not know what he meant by I'm not comfortable, I don't know what's going on. He later stated that he was only referring to the handcuffs, but he very clearly, no matter how ambiguous those statements were, he very clearly stated, I wish to plea.
I guess I wish to plead.
I just,
Well, he says, I wish to plead 3 times.
I
Yeah.
guess I'll plead. Yes.
I wish to
does.
plea, I guess I'll plea, I want to plea. I don't actually.
But- And then he follows along with but I don't understand what's going on, but I don't know why I'm even here, but I'm scared. All before we had the confusion about raising his hand.
Right, but we have, I wish to plea, and then he has, please raise your hand, and then he says, I'm not comfortable. Again, he says that he was referring to the handcuffs. Again, that statement may have been ambiguous, but he did state, I wish to plea. And then he says, I don't know what's going on today. Again, he states that he was referring to the handcuff
And even
raising process.
before then, lawyer, they're whispering in each other's ears. Lawyer says, well, looks like we have a trial. And Mr. Bruning says, I didn't say that, which is another indication that he wants to take the play. Mr. Bruning's a difficult guy. Okay. There's no doubt about it. This is a horrific crime, but his own lawyer later on, before the trial started, said, I want to put on the record, I think he's not competent, that, the government's psychiatrist says he is, but he refused to be examined by defense. So he's a difficult guy. I mean, he says, 3 times I'll take it. If he would have affirmatively said, okay, I've changed my mind, no, but a guy's handcuffed, raise your hand, and all of a sudden it's over. Something doesn't smell right about it to me. We can have 6,000 other cases, but we're talking about this one. And if the judge would have just gone through it a little more and said, look, Mr. Bruning, this is it. Are you taking the plea or not? Otherwise, we got a jury here, let's go. But all she kept talking about is, do you want to change out of the jail clothes and wear a suit?
Isn't it the prosecutor's purview to withdraw pleas? It's their purview to extend them, a plea offer, and it's their purview to withdraw it, correct?
So I think okay, yes,
Okay.
correct.
So Mr. Boisvert, obviously there had been pleas offers along the way, right? And there was the plea offer that was made and that Mr. Miller and Mr. Denny had a chance to talk to Mr. Bruning about, right? Within the 5-minute period of time.
Correct.
And they came back and it was Mr. Miller who said, looks like we're going to trial. So the 2 attorneys that he had, who were the head of the defense group that we have here in Kent County, came back and said, they both talked to him and said, okay, we're going to trial. And he's like, wait a second, that's not what I said. But then everybody tried to go ahead and say, okay, this is what we're going to do. If you're going to take the plea, then, and then he kept equivocating. And that's the part. I understand that Mr. Boivay could have given 10 minutes. He could have given 2 minutes. He could have given 1
They
minute.
could have said, let's adjourn it for 2 weeks, but they didn't.
If the prosecutor had affirmatively revoked the offer, I would agree. However, he gave him 5 minutes to make a decision, and within that 5 minutes, he did make a decision. And I would say some of what we're talking about is just evidence of the breakdown in the attorney-client relationship, which was the making of the McCoy violation. Because later they do say that they did have difficulty communicating with Mr. Bruning
But
in their
that
motion
doesn't-
to withdraw.
But that doesn't mean, that doesn't mean that they didn't talk the same language. That could mean he said one thing when we talked to him and he said another thing when we were in court. It could have meant a lot of different things.
Right, but we don't actually know what that conversation was, and the only way to really
We
find
won't.
out what that was is for an evidentiary hearing, which we don't have here. We only have the counsel stating that they cannot effectively communicate with Mr. Bruning because they do not think that he's able to effectively communicate. And then you do have counsel coming back and saying, it looks like we're going to trial. But then Mr. Bruning very affirmatively stating, no, I said that I wish to plead.
But again, yes, all right.
Did, and I know I should know this, counsel, but did you make a motion for Ginther?
Yes, Your Honor.
And our panel denied it without prejudice to the ace call panel ordering one. Is that correct? That's usually, if we're here and we haven't had one, that's usually what the order looks like. Do you know?
I unfortunately
Ms.
do not
Blodgett,
know.
I think is nodding. Okay.
Okay.
All right. Okay, thank you,
All right,
counsel.
any other questions?
I know.
All right.
Very, very excellent job in your oral presentation, counsel. Thank you.
And you
Thank you,
did,
Your Honor.
there is some time for rebuttal if you need it to.
Good morning, Audra Blodgett, Kent County Prosecutor's Office. There has been a thorough discussion, I think, of both sides of this brief. Just to meet some of Judge Kelly's hesitancy with the facts, I will point out that at the beginning of this plea colloquy, or I should say discussion of the plea between the parties, it does begin with multiple thorough explanations of the plea before the defendant. The prosecutor puts the full plea on the record. The defense counsel discusses the plea with the defendant. When he expresses some confusion, the court again explains the full offer. Defendant again says has some questions, asks if there's a parole thing. Again, counsel and trial court both again explain what the plea deal is, what his parole outlook would be. They field several questions from the defendant about his options going forward, what the verdict form would look like. And then it does devolve into a quick back and forth where it does seem like it is a more time pressured situation, which I think is where the hesitancy might come from, saying that he had time to consider his options. But I think in the full context of this interaction, at the outset, he's given time to consider, time to confer with counsel, and continually just doesn't want to go to trial, I think is what reading between the lines. He doesn't want to go to trial. He doesn't want to plead. He doesn't want to be in this situation where he's facing a significant sentence. But defendants don't get to decide whether they go to trial. He's going to trial if he doesn't plead. He doesn't have a right to a plea, but the prosecutor offers him one. And when it's revoked upon his continuing equivocation, there was no other option but to go to trial. I don't think I can identify anywhere, I don't have the full transcript before me, so I defer to the court, where defendant says, I wish to plead. He says, I guess I'm taking the plea deal. I guess my decision would be to take the plea. I guess, I don't know. So I would defer to the court, and I don't see anywhere where it is that definitive of a statement alone. I wish to take the plea. And then the first step is engaging in the oath. So even once defendant says, I guess I'm taking the plea deal, they proceed into taking the plea deal.
Well, they must have taken, I guess I'll take the plea as an acceptance of the plea.
I think so.
Let's not play with words.
Yes.
They
and
wouldn't go to that stage and say, raise your hand if they didn't believe he said, I'll take the plea.
Yes.
So now
but
we have a
not-
guy in handcuffs and they say, raise your hand, and he's doing this or whatever, raising both hands, and it all falls apart from there. He's asking questions, he's not sure, he's being difficult, which he's been the whole time. And rather than wait 2 or 3 more minutes and smoke it out and get him to say yes or no, it's all over, and in marches the jury pool.
Yes, so the last thing he says is, I guess I'm taking the plea deal. And if your honor would, for argument, if that is accepting the plea deal, I guess I'm taking the plea deal, then they begin the plea process. They say, okay, the first step is, they don't say this, is raising your hand. Raise your hand. He stands still. That is part of the record in the motion before the trial court where he wanted to revoke, or I guess, go have the plea reinstated. The trial court specifically says in the transcript, I was there. You didn't want to go to trial. You're facing the open murder of a friend. But when asked to raise your hand, you stood still. So he wasn't like trying and the court's like, oh, well, I don't want to see this. I want a trial. Like, I don't care if you want a plea. He's standing there refusing to engage in the first step of, I guess, the second step of the plea process. So even if he says, I guess I'm taking the plea, he can't stand there mute and get a plea deal. He has to engage in the plea colloquy. He has to take the oath, even if sister counsel is correct that he doesn't need to raise his hand. But he'd need to participate. He would need to say, no one promised me anything. There are no threats. Yes, I agree. That is, the police report is the factual basis.
But it didn't get that far, did it?
Correct, because he did not engage in even the first step of participating in the
Which
oath
was
taking.
apparently raising his hands.
Yes.
And if sister counsel is correct that he doesn't have to raise his hand, then that might be a problem.
I would say that issue wasn't briefed. It wasn't brought before this court that there was any legal error. I would also point out the standard of review in this case is an abuse of discretion. So even if we were to say there may have been, if I was in that position, I might have done it differently. The trial court in accepting or rejecting a plea offer is reviewed for abuse of discretion. So I can't say that Judge Mims' decision after having a plea open for a year and engaging in 30 minutes of a plea call or plea discussion with defendant, allowing him to confer with counsel, going back and forth on what this might mean, having the prosecutor read the offer multiple times would fall outside the range of a reasonable and principled outcome. So I think even under the standard of review, it's a higher burden.
Should we send this back for a hearing?
I don't think it is necessary. I think the issue of the handcuffs is already resolved in the record because the judge did address this motion of reinstating the plea in the lower court. Obviously, we'd prefer that over a complete reversal of the case if the court did have questions, factual questions about representation. But I think there's enough on the record to decide the case.
Was it going to be a no contest or a guilty plea?
I will agree with sister counsel that, and I take, it wasn't her briefing, but her previous counsel's briefing and my own did say guilty plea, but upon review of the transcript, it does appear no contest. The prosecutor said upon successful plea, and then it was later clarified by defendant's counsel that it was a no contest. But I don't think that changes.
Still a plea. It's just
Correct.
with the impact of guilt, but it's certainly the.
And defendant still could not just stand there and
No, I
have it read to him.
Don't disagree.
So, Ms. Blodgett, according to the transcript, it says at 10:45 a.m., Mr. Bruning talks to his attorneys after the plea has been offered. And then at 10:57, the court finally says, time's up. So, because Mr. Boivin made it very clear that the offer was available for 5 minutes.
Well, no, the first time he says approximately 5 minutes, right? I'm going to give him approximately 5. If we've got a stopwatch on and they miss this, and it's not up to the judge to revoke the offer, it's up to the prosecutor. But the first word was approximately 5 minutes, not exactly 5 minutes. They later say 5 minutes.
So do you, in response to Sister Counsel's argument, do you agree that it had to be Mr. Boivin to say, I am withdrawing the offer?
I do not think there is a requirement that the prosecutors say these magic words to withdraw an offer. I guess if there was one point for a Ginther hearing or an evidentiary hearing, it appears he's my colleague and I still butcher his name, Boivin.
That is correct.
Thank you. does attempt to jump in on the transcript, says, Your Honor. So I think there could have been physical indications that like everyone was over it at this point. They are ready to go to trial. The jury is waiting. The prosecutor's like, Your Honor, this is done. Like, we're over it. So if that is what this court believes this case hinges on, that I guess would be one area for factual development. But I don't believe that there needs to be a verbal revocation once a time limit has been set.
I don't have any more questions.
Thank you very much.
Some rebuttal?
Just quickly in response to the standard of review issue, this court has held that an error of law is necessarily an abuse of discretion. And here, outside of the hand-raising issue, during the discussion or the ruling for the Sixth Amendment violation, the court did state that there was no prejudice to Mr. Bruning from counsel's error, because he had a trial and had all the rights afforded therein. However, I would just point out that the U.S. Supreme Court rejected that exact argument in Lafler, that there can be no Strickland prejudice if the defendant otherwise had a fair trial. Rather, the appropriate inquiry is whether or not the trial cured the particular error at issue. And when we're talking about a plea bargaining process, prejudice can be found if the loss of the plea opportunity resulted in more serious charges or a more severe sentence.
Okay. I think we're set. That was a very
Thank you.
lively argument and appreciated both of you. That case will be submitted. Brings us to item number 16. Item number 373949, People versus LaShawn Jamali Likely. Ms. Blodgett, we received word that Mr. Ferry waived argument. Okay.
Good morning, Audra Blodgett, Kent County Prosecutor's Office. I don't have anything to add to my brief, but would be happy to answer questions.
I have none myself.
I don't have any.
I have a question here. It says, what duress at the time of the plea?
I also had that same question. I don't think it was adequately briefed. I reviewed the transcript and didn't see any duress avail or obvious to me. I don't think it was pointed out in the brief. So I am equally without answer to that.
That's the only question I had.
Okay. Thank you. That will be submitted. Item 17, docket number 371,889, People versus Alexander Reese Geary.
Morning.
Morning.
Morning, Mr. Ambrose.
So Ronald Ambrose, parent on behalf of Mr. Gary. One issue in the case, and it's more or less a statutory interpretation of the statute. I did file a motion for a new trial, raising a Ginther issue and trial counsel not raising a jury instruction on if this place could qualify for Mr. Gary's residence. And the statute does exempt a person from being prosecuted if this is in fact his residence. That's the only issue in the case, the statutory interpretation. I kind of went down the rabbit hole a little bit on it.
The facts require that, Mr. Ambrose.
Yes, well, they did. You know, the court remarked that Mr. Gary was a squatter. And, you know, there is a statute with regard to squatting. Squatting more or less takes into account that this person is actually living there. And lawful possession of a residence or lawful presiding at a place is not a requirement of the statute. So that's the nuts and bolts of our argument.
Okay, think I
As always,
understand it.
you always, I'm always glad to see you on our cases. You always do a super job and I was stretching my brain on this as I was reading your brief. I'm like, oh my gosh, Mr. Ambrose, man, you're really making me work on this one. So thank you.
Appreciate that.
Yeah, no, it was good.
Mr. Ambrose, do you believe that we need to publish on this?
It'd be helpful. There's, you know, I cited the squatting statute. I was hoping to get more information from that from that statute, and there's really not a whole lot there. Yeah, I wouldn't,
The squatters of Michigan need clarity in this area of the law.
well, there are unfortunately some people on that area that
Right.
may want some guidance.
And I'm not sure, I can't remember if this was included in the discussion with respect to people who are homeless, people who are, have challenges, because we have a lot of different people who are struggling with housing insecurity.
As I was thinking through this issue, I was like, well, if a person is out in the wilderness at a campsite or something, or what have you, are they allowed, this land is not, in their name, but they are possessing it for a period of time. Are they still allowed to carry fire?
Well, the same thing if they, if people are,
Well, their campsite or their boat or things like that, they would be able to, I would think, or maybe not their boat, but the campsite. if
Well,
it's-
I used campsite, but let's say they are out on public land.
Oh, okay, not
You
an
know.
actual, not I've got a reservation.
Yeah.
Okay.
I mean,
Yeah.
whenever I can fit running into an argument in the Court of Appeals. There are some like ultra marathons,
Yep.
where people are out on, for days.
110 miles.
Yes. Are they allowed to possess any
I don't think so.
protective?
Too much extra weight.
Well, yeah,
Have to
it
carry around.
would bog you down a little bit.
But I think more about, people staying in abandoned buildings
Yes.
or, in somebody's garage, when they know they're not there, they can tell in the wintertime, the driveway isn't plowed and it hasn't been plowed. And they find a way into the garage or into the house that way.
Might be different. I could see a difference between an abandoned building where no one has a expectation of the use of it and a temporarily seasonally unoccupied garage. But hard to know. Okay.
All right,
More to
thank
think
you.
about.
Yeah.
Gosh, okay.
Good morning, Honors. John Donaldson representing Ottawa County. I would rely mostly on my brief. I would cite that I believe the cases that I cited in my brief indicate that to use that exception, you would need some sort of possessory interest in the property that you're on. I don't think there's anything establishing the defendant had any possessory interest in this house being built.
He made statements, is my recollection, that he was a tradesman, was allowed to be there.
Yeah.
Does that,
So,
does
yeah,
that matter?
this was a house that was still being built. When the worker showed up to work on the railing, they found the defendant inside. Defendant told that worker that he was also working on the house when he
Right.
arrived there, not that he was squatting there.
But that was nonsense, right?
That was nonsense.
Yeah,
That is correct.
okay.
But his spidey sense figured out that I need to call the police and wait.
Hey,
block it
Yes,
here.
He
yes.
blocked the
But
gentleman's car.
there you go. But then, yes, and that was interesting that he did block his vehicle and that he couldn't get out. But then he kept saying this David Kerr was also there.
Yes, and that was my other argument in my brief, on top of, even if you want to, for argument's sake, even if you want to say it was his residence, we're still talking about trial strategy, because to ask for this instruction, he would have had to admit the guns were his. When the counsel during trial argued that these guns belonged to somebody else because the defendant was never seen with the guns in the car, they weren't fingerprinted, they weren't DNA sampled. So I believe that even if you want to argue aside that for some reason you think that instruction would apply, it still goes to trial strategy that the council took to argue instead that the guns belong to somebody else, and arguing for this instruction would have conflicted with the trial strategy that that council took at trial.
Okay, thank you.
Thank you.
Any rebuttal?
Yeah.
All right, thank you
Thanks.
both. That case will be submitted. On to item number 19, docket number 371643. No, I'm sorry, we're on 18.
18.
Yes,
Thank you.
371577, People versus Felicia and Bishop. Mr. Nunley is appearing remotely, I believe. You, Mr. Nunley?
Yep, can you hear me?
Yes. Why don't you go ahead, put your appearance on the record and go right ahead.
Of course, Royce Nunley appearing on behalf of Felicia and Bishop. I'd like to first and foremost thank this honorable court for allowing me to appear via Zoom. It's a little bit of a hike to get out to Grand Rapids from where I am, but I believe that the issue presented in this case is pretty straightforward. There's a video that's been submitted. I don't really have anything to add to my brief, but I'm happy to entertain any questions if there are any.
Yeah, well, I don't have any.
No,
think
I
it's-
don't. And thank you for attaching the video to the documents. I don't know how you do it, but they magically got to my computer and I was able to watch it multiple times. So thank you.
And you can't imagine how many times we don't have.
Right.
It's coming up on case call, we're like, where's the video? Everybody's referencing and we're like, oh, well, nobody submitted it. So,
Yeah.
yes. We
Yeah,
appreciate it.
we always try to make sure we get like 4 or 5 of those little flash drives and mail them out to everybody, so they're available.
Well, you did well. Thank you.
I knocked it out of the park. I like it.
Good morning, Your Honors. May it please the court, Amanda Ingram of the Kent County Prosecutor's Office on behalf of the plaintiff appellee, the people of the state of Michigan. I too will rest on my brief, but would field any questions you may have.
No, that was well covered by both sides. Appreciate it very much.
Thank you.
And with that, there's nothing to rebut. So case will be submitted.
Okay.
Thank you.
You guys have a great one.
And now we turn to item 19, docket number 371643, People versus Timothy Richard Woodcocks. Why don't you come on up here so we can pick it up? No, I mean, right up to the podium so we could pick you up on the microphone.
I just want to make clear, I'm not endorsed for.
Right,
Right.
so. Yeah.
Good morning. Again, I'm here on behalf of the defendant appellant Timothy Woodcocks. The issue in this case is fairly straightforward.
Well, no, you don't have oral argument, but you said
Okay.
you wanted to make your
Okay.
presence known.
Oh,
So
thank you.
we just wanted it to be
I
picked up on the
apologize.
microphone.
Kathy Springstead on behalf of the defendant appellant Timothy Woodcocks.
Thank you very
Thank you.
much. Okay.
Good morning again, Your Honors. Amanda Ingram of the Kent County Prosecutors on behalf of plaintiff appellee, the people of the state of Michigan. I would also just rest on my brief, but again, if you have questions here.
You concede error.
Oh, yes. Well,
Okay, so it
it's-
has to go back.
It has to go
Okay.
back for
All right. I
sure.
wanted to make
It's
sure we're
the
on the
only
same
issue
page.
I would be willing to discuss if needed, beyond that would be the SORA, the registration. So which is definitely a conflict that is going to need to be addressed at some point by the legislature or the courts through interpretation, but we haven't had that injury here, so.
All right.
Thank you.
Thank you. That'll be submitted. Brings us to item number 20, docket number 370352, NRA VH.
Morning, Your Honors. Roland Lind on behalf of appellant Vincent Hagar.
Can you speak up a little bit?
Roland Lind on behalf of Vincent Hagar.
Great, thank you.
I see, Mr. Lynn.
Your Honor.
We call you Major or Lieutenant Colonel now?
Major retired.
All right. Fine, Marine.
The case really revolves around this, and it's how should the court understand the following phrase the lower court pronounced, and I'm looking at page 43 of the transcript, starting at line 10. Quote, and given the fact that the court has previously found that Mr. Hagar did receive notice, given the fact, the appellant's argument is that that is indicating that the court is using its earlier preponderance of the evidence, lower standard to determine that he knew about the PPO. Of course, that would be something that would have to be proven beyond a reasonable doubt, not just that the violator had committed an act that was in violation of an order and that that act was intentionally done, but thirdly, that it was done knowing that it would violate the order.
I thought that there was either argument or it probably was just argument, Mr. Lynn, that right after he was served the second time that he contacted the petitioner and made reference to
So for some reason, the way it seems to proceed in some kind of bifurcated fashion where when defense counsel, and it wasn't myself, the defense counsel at the time tries to get the whole case dismissed on the argument that the PPO itself wasn't properly served. And so the judge takes some testimony about the service and here's evidence that, you know, even evidence from Mr. Hagar himself, but that evidence included some text messages that seemed to indicate that he knew about it. But then the court rules the dismissal out of order or denies the dismissal based on the lower standard. That's found on page 24 of the transcript. And that starting at line 21, the standard of proof or burden of proof is a preponderance of the evidence, which is very low. So the judge then makes that determination. We can move forward. I'm not dismissing this. Let's move forward. Takes more testimony that gets at the evidence that he visits her, does other things. And then when she finally makes, the lower court judge finally makes her ruling, she says, I find beyond a reasonable doubt the respondent is guilty of the criminal contempt. And then she says, even if I disregard the phone calls, the alleged phone calls, it's clear that Mr. Hagar did appear on the property. So there, the appellant's argument is, yes, the lower court judge, finds beyond a reasonable doubt that he appeared on the property. But the knowledge of the PPO, which would make him guilty of and then eligible for liable for the punishment, that's based on the fact that she had found earlier by a preponderance of the evidence that he knew about it.
Okay, I'm taking my appellate hat off and I'm putting my circuit court hat back on because I conducted lots of these. And I don't remember ever there being a requirement or being asked to make a finding on service again, once I've made a finding on service, because that's essentially what you're asking. You're asking that you have to find service at the beginning beyond a reason, by preponderance. And then at the violation hearing, you have to make another finding regarding service beyond a reasonable doubt. And I have never done that and not aware of any court rule requirement or case that requires that. Because that's exactly what you're asking.
No, I'm asking the court to follow the court rule that says that for a person to be found guilty of criminal contempt, they must be found guilty of willful disregard of the PPO beyond a reasonable doubt. So the reasonable doubt standard applies to the willfulness element, not just the act itself and the intention behind the act, but also that it was done willfully in disregard. So you could do an intentional act that would violate a PPO, but if you didn't know that there was a PPO enjoining you from doing that,
Again, but she already made that determination.
my argument, Your Honor, is that she made that determination by that lower standard.
Okay, but where is the case or court rule that says when you make the determination at the violation hearing, you have to remake that determination beyond a reasonable doubt? Because typically when I would cancel PPOs all the time when people didn't show that they were properly served, right? We would come, they'd bring in the individual, we'd find they weren't properly served. We would serve them and send them away. See you later. Adios. You know, PPO's in full force and effect. Don't violate it. Any questions? All the rest of that. But again, I've never seen a case or a court rule or a common law that requires, once you've already made the determination that they have been served, you have to make that determination again at the violation hearing beyond a reasonable doubt, because you've already made that determination. They were served. I think it was a relative in this case, wasn't it? Who signed the proof of service. And there we go. I can't remember if they testified, they took testimony regarding the service or not.
No, actually, some of that evidence comes in as hearsay. The attorney at the time didn't object to that, so I guess I have no,
Okay.
that's been waived.
But again, can I, let me, and I'm talking too much, I apologize. So where's the court rule or the case law that says at the violation hearing, they have to make another determination regarding service beyond a reasonable doubt?
Well, I cited in re contempt of Rapanos, 143, Mishap 483, which in turn cited another case. It's page 9 of my brief. And the prosecutor must prove, among other things, the defendant, quote, engaged in a willful disregard or disobedience to the authority of the order.
Yep.
So
They were served with the order. It was already determined he was served with the order.
but that was determined at the violation hearing.
Yes.
But it was determined by that lower standard of proof.
Okay, so do you have the case that says that you have to determine it by the higher standard of proof at the violation hearing? Is that what you're talking about, the 143 Mishap 483? Because I feel bad if I did it really poorly for 22 years.
Well, okay, the prosecutor must prove the violation beyond a reasonable doubt. Michigan Court Rule 3.708, paragraph H, paragraph 3. People versus Little, 115 Mishap 662. It's a beyond a reasonable doubt standard on all those elements, including the willfulness. I don't think that's. I think the question for I think that's something the panel should accept and move on to really the nub of this is how to understand. In other words, does Judge McNabb, the lower court judge, by saying, I find the defendant guilty of criminal contempt, does that cover all three elements? By saying that, does she mean I found all three elements beyond a reasonable doubt? Or, as I'm arguing, as the appellant's arguing, the phrase she utters just before that, and given the fact that the court has previously found that he did receive notice, that's indicating that on that element, she's referring to her preponderance of the evidence ruling that he knew about it. She
And
never says,
Go ahead.
unless the court, this court, is generous with their understanding of what she meant by, I find him guilty of criminal contempt.
Well, contempt proceedings are by definition summary proceedings. So they're made to, by design, to allow the court to either A, obtain compliance with the court's orders, or to B, to punish the contemnor for previous violations. So the procedural due process that a potential contemnor has is it's not a full jury trial. I mean, it's a proceeding. Does that aspect of the statutory construct for contempt under Michigan law, does that affect in any way the efficacy of the argument that you're presenting?
I don't think so. It would just be important that whoever is determining guilt or innocence, sorting that out, that they do it understanding the proper standard to apply. And the proper standard was beyond a reasonable doubt based on what I've already cited, what's in the brief there. I don't think that's a question. The question is that what the judge is doing here? It doesn't seem like it to me.
Mhm.
I know that the people think otherwise, that people think that that phrase, guilty of criminal contempt, and also giving that the court can give the lower court a little wiggle room here. But to me, even if you're going, you lose that wiggle room when you read the phrase that preceded this. The Judge McNabb is saying, given the fact that the court has previously found, that seems to imply that other previous ruling that was on that lower standard is upon which she's now basing her decision to find him in contempt. That it is connected. It's not bifurcated. This whole thing was, am I going to apply the correct standard to what I need to do, which is to determine whether he did an act that was in violation of the order, that he did that act intentionally, and thirdly, beyond a reasonable doubt, that he did that willfully disregarding what he knew he was enjoined from doing. And one of those elements, based on that phrase, in my opinion, not the proper standard. Okay.
Thank you.
You have time for rebuttal too.
Good morning, Your Honors. Amanda Ingram of the Kent County Prosecutor's Office on behalf of Plaintiff Appellee, the people of the state of Michigan. I would first like to point out that this court very recently clarified the review standard. 1 month ago, the published decision in Ray Tauber, it's docket number 371447. They clarified that it's.
Can you give that docket number one more
It
time?
was 371447. And that the review is to be taken in the light most favorable to the trial court's factual findings, not the trial court, not the light most favorable to the prosecutor, because so that's been changed since briefing here. But I would like to note that in that case, this court's also clarified that for criminal contempt, there are 2 elements, not 3. 1, the willful disregard or disobedience of the order of the court. And 2, the contempt is clearly and unequivocally shown. So, and yes, the rest of this is argued in my brief, but the people would simply argue that, or excuse me, petitioner would simply argue that the finding of service was just one portion. It didn't have to be found again in answer to Judge Feeney's question. Whether it was willfully violated, it doesn't, the service is just one portion of that knowledge. The facts also show, and the court found that, he also went to her house before the date, and this is in the time where he says he didn't know about it now.
And isn't this the one where he put his finger
He
over
covered the ring
ring?
camera, correct. And he had also called her in that time too. So it was just one facet of showing that beyond a reasonable doubt that he willfully violated this order that he knew existed. If there are any other questions?
EJ, can I have just a second? I want to take a quick look at this case.
It's very colorful.
The one you cited or this
The
present?
one that I cited
Okay.
involves a Zoom call and some comments that the attorney did not realize were still live.
Oh, it's that one.
That one.
One of those. Yeah.
I had one of those.
Yeah, that's a.
Yeah.
Beginning of COVID. Judge Borello was PJ. That was enlightening. Yeah, yes,
Yeah.
yes.
I suppose if it helps then too, I could add that they also, that in that case, the panel also defined willful disregard as an act, omission, or statement tending to impair the authority or impede the functioning of the court. So whether that's helpful or not.
Okay, okay, thank you.
Thank you.
Thank you.
Mr. Lind, any rebuttal? Okay, thank you. That'll be submitted. And that brings us to, I think, our last case for the 10 o'clock call. before we
So
take a
much
break.
better today.
Yes. And this is item number 21, docket number
Don't
369.
jinx us, Judge Feeney.
Sorry.
571 Farm Bureau Mutual Insurance versus Blarney Castle Oil.
And for those of you who weren't here yesterday, we were on the bench till about 4:45. So.
John Coretti on behalf of the plaintiffs appellants. Thank you, your honors, for hearing my case and allowing me this opportunity today. In reading the judge's opinion, I think the biggest error is her reliance on two cases that have absolutely nothing to do or no bearing on this case, the Feeney and Gerben case, which were decided under the Michigan Public Utilities Act, which Blarney Castle is not a public utility. And they were neither delivering gas nor electric, which that act applies to. They were delivering heating oil. And that act does not even apply to heating oil. And from those cases, she adopted the duty that there's only an obligation to deliver it to the exterior of the home. That's it, period, nothing further than that. From there, she went to foreseeability and said the damages were not foreseeable because when the delivery person was delivering the oil, it was a slow fill, which is the other error in this case. There is no such thing as a slow fill, and it's based upon a misrepresentation by defendant that somehow because the hose was pulled out or extended 60 feet from the truck, the oil could not go through it fast enough or at fast enough rate to activate the whistle alarm on these tanks. The whole purpose of the whistle alarm is to prevent spills. That's why it was invented. For remote fills where the tank is not in sight, it may be inside the house. So they listen for a whistle. That is the sign. No whistle, no fill. These hoses on these trucks are wrapped up like a garden hose. And they're anywhere from 150 to 200 feet long. So the oil going through that reel, whether it's pulled out 10 feet, 60 feet, or 150 feet, has to go through 150 feet of hose. So whether it makes no difference on how far the hose is pulled out and whether that would make it a slow fill and not fast enough to activate the whistle. In fact, physically, common sense and physics, if it were pulled, the farther it's pulled out, the less friction there would be because it's going around less reel. It'd be flatter, it'd be faster or anything. The rate would be faster going out the further it's extended out.
You had an expert that said, if it doesn't whistle, you stop filling.
Absolutely.
So whether or not it's 2 feet away or 200 feet away, that your expert definitively stated that, correct?
That is correct.
All right.
And we have the only expert opinion in this case. Defendant presented no expert testimony to contradict it or contrary testimony. And then the judge went on to add, ignored our expert opinion of the no whistle, no fill, and went on to create her own standard of care that if the standard of care is you fill it up till it overfills out of the vent or the fill tube, no harm, no foul. That's it. That's the way you determine it. And which is absolutely.
And how much leaked out of this into their houses?
275 to 200 gallons of oil.
A lot of oil.
It's a lot of oil.
Yeah.
It was a huge mess and there was a huge environmental cleanup. It's on a lake. If you envision the oil spills you see on the news with the floating floats in the water to contain any oil that, leaches down, like that's what this was. There was
Well, they had booms on the lake.
in front of the house. They had it out there just as a precaution. They had to make sure. I mean, it was in the winter, so of course the ground is frozen. So if it hits the ground, it most likely is going to go across the top. So whatever, they took all precautions. Everything was done as a precaution.
There was some discussion of that. The one fill in November, they topped it off at X number and it was maybe 10 gallons too much. And then immediately thereafter, the plaintiffs went to their warm weather place for a couple of months. And then January rolls around and they get a bill for another 290 gallons. And they're like, well, gosh.
Was it January or was it later? I thought it was.
Yeah, it was
January.
Yeah,
Oh, okay.
So it's 2
yeah.
months after the November fill.
And they haven't been there. So they're like, oh, maybe we left the furnace on or whatever.
Correct.
It seemed that there was some discussion at the trial court that, hey, if they're leaving, they should have told their ready fill guys that. What do you make of that argument?
Well, they've been customers of Blarney Castle for 6 years. They were never asked to provide information regarding winterization. They regularly winterized. There's no written policies that say, let us know when you winterize. And so they never asked for that information. They never provided that information.
And the whistle should have taken care of it anyway.
That's why we have the whistle, because, living in Michigan, there's probably thousands and thousands of cottages in northern Michigan that are winterized and they're not used in the winter and they are heated with heating oil. And some of them are used for snowmobilers, some of them are not. But that's why it's a fail-safe and common sense standard. You don't hear it, you don't pump. And the expert testified that, a couple things should have happened when he didn't hear it in November. Is he should have stopped filling it, of course. They should have sent some type of notice to the homeowner. They didn't need to go and service it, maintain it, or check it any further, but they should have said, hey, we were at your place. We didn't hear a whistle. You might want to send someone out to check on
Your
it.
clients are not claiming that the fuel company had an affirmative duty to go in, even though it was an unsecured space, and to
Correct.
go in and inspect. That's not a theory of liability.
No, their duty was to stop pumping. And if before they pumped any more, just as common sense, they should have notified them that there was a possible situation. And, as I was actually just sitting here waiting for the hearing, more arguments were coming to my mind. The January delivery note says slow fill, no whistle. Well, then I'm thinking of their argument that the slow fill was caused because 60 feet of hose were unwrapped and it was too far for it to pump at a normal rate. That is an issue with their truck. Yet the court assumed that's an issue for the homeowners, that it was a slow fill. They didn't maintain their tank. How is that their fault if the truck's not pumping oil fast enough to activate a whistle? Now, I don't believe that by any stretch. I don't believe that that's what happened. There was no problem with the whistle. We know that.
And is that something that the court said? I don't recall that, because when I read that, I thought it was the problem with the truck, like you said. But did the court say that she saw it as the?
Yes, she said this proximate cause of this damage was the homeowner's failure to notify him of the whistle or of the winterization and failure to maintain their system. That's why.
So that's where you say she connected the slow fill with failing to maintain a system.
Yeah.
Okay, thank you.
Yeah, so I mean, it's just, and by admission of the attorney saying that 60 feet was too far for it to pump oil at a rate to activate the whistle. That's a problem with their equipment. To me, that's 100% liability right there. If you're using equipment that's not, with a pump that's not strong enough to activate the safety whistle that's been used for hundreds of years on these types of systems. I forget what year.
No, but hundreds, maybe 100.
100 years, I'm sorry. It's been around
I
for.
don't think we had liquid heating oil at the
You are correct.
origin of the nation.
I think I put in my brief because I looked it up. I think it was invented in like the 30s or something like that, or 40s. And
Right. No, you did have it in your brief.
yeah, and it's been around for a long time.
Yeah,
And I would think that anybody that builds or designs a truck to pump oil, heating oil, is going to do it with enough pressure to activate a whistle, which it doesn't take much to activate the whistle.
And that's what I mean. Did the expert talk about that? Because
Yeah.
even when I was trying to, in my head, because I'm a visual learner, I'm like,
Yep.
okay, how would that operate? So it's just the displacement of the air.
Yes.
And so I can think of other things where you do the same sort of thing and you can hear, like I was filling a vase that had a really narrow neck this morning.
Yep.
And as I'm filling, I can hear, you know what I mean? Like the air escaping out of there. So it's nothing more than that, right?
You're right. A toddler could activate the whistle. It's
Okay.
it's that light of a whistle. And I think, and I don't have an expert here, but I think that as the air escapes the tank and there's less air, it's going out faster. So the whistle would actually get louder and louder and louder, I would think, until it finally stops. It seems to make common sense, physical sense, that that's what the case would be, because there's less air is being dissipated faster because there's less of it, and it's going faster out of the whistle. It would be louder at the end than in the beginning. But I'm not
Then
positive, but
let me ask one other kind of silly question. So then does that mean if there's no whistle and the tank is operating properly, it's the fact that the oil's at the level of the whistle that says, stop it? Okay, thank you. Just
So
wanted
you,
to make sure.
when there's no whistle, there's a couple circumstances that could be the reason. It's full, or there's something wrong with the whistle, which is highly unlikely. They're not mechanical. It's just open. It's a whistle. There's nothing in there that moves. They can get, I've heard of circumstances where they get clogged, but the fact that this wasn't clogged, because we know that oil came out, he overfilled it. It came out of it. If it was clogged, oil wouldn't have come out of the vent pipe. It would have been, if it had been clogged. But anyway, I would like to add, regarding after they filed their motion, I added, or requested leave of the court to amend the complaint to add the trespass count under the Michigan statute for the oil spill. And I thought it was interesting that the court denied it, because you can't have trespass if it was negligently caused. So she denies my negligence claim, yet says I can't proceed with trespass because it doesn't apply when it's negligence. It seemed kind of
Inconsistent.
inconsistent. to say the least.
Intuitive.
So if you have any other questions, otherwise I'd like the opportunity to
No.
rebut
Sure.
opposing counsel. Thank you very much.
Rodis for this defendant appellee. So there's a number of things I want to address, but I think first of all, we have to agree on what the relevant law is, and counsel's suggested Feeney and Gervin are not relevant, but I have to ask then what is. Plaintiff is the one that needs a duty to have a negligence action, and I submit that the duty here has to be controlled by those cases.
You speak up just a little bit.
Yeah, I'm sorry, I'm under the
Okay.
weather a little bit, so I'm having
Okay.
trouble projecting. It's not for a lack of enthusiasm.
We bring one of those ear trumpets next time.
Yeah, maybe. Oh, gosh. So we got to have a consensus on what the governing case law is. And I don't think we can really get past go if we don't agree that Feeney and Gervin are the relevant standard. That there's really no other suggestion of what would be the standard in terms of what our duties are in this situation. And that's the rubric that's got to fit in, I believe. There's not a lot of case law following Gervin. It's a 1999 Court of Appeals opinion. There's a relatively recent published case that hints that it's actually the same parties. It's another subrogation case by Farm Bureau against us. But that's case number 364960. Page 3, note 3 of that cites Gervin, not dispositively. It's just a passing comment. But to me, I think the lack of any other rubric to fit this in terms of a tort concept is kind of hints that that needs to be the standard. And it's hard to go forward if we can't agree on that. But to answer the other arguments, the whistle, I think it's a red herring for a couple of reasons. The November delivery was conducted without incident in the absence of a whistle. You didn't hear a whistle. Again, that was the slow fill. That's the basis of the slow fill, is the same delivery person's experience in November. When he came back 2 months later, he remembered, I didn't hear a whistle. It still took about 90 gallons. And then he saw a little bit of leakage from the top, which clued him in that it was full. When we come back in January, if there had been a whistle, this would have played out much the same way, because it just would have whistled the whole time. It was still displacing air when it was going in. That's the whole problem here. And this is where the winterization comes into play. The tank, he pumped 285 gallons. We're told this 275 gallon tank. That in and of itself is not an indication of a problem because everybody agreed that they have excess capacity. So what made him stop was when it got to 285, he says there's something wrong here. It maybe gets to 275, it doesn't get to 285. But because of the winterization, he doesn't know about, it's completely plausible that it's empty in the last 2 months if somebody's been in there from his
Right, but
perspective.
isn't there evidence of record that these plaintiffs winterized this home multiple times, multiple years when they were in a contractual relationship with your client?
Right, but what I'm saying is from his perspective, it's plausible that it's been used that in the 2 months that they would have burned through it all. That's why he doesn't shut it off earlier. That's all I'm saying.
Right.
So that's why he lets it get to 285.
They have an expert that says, if it doesn't whistle, you don't pump. You
That's-
don't have anybody that says anything contrary to that.
No, but that's another issue. I don't think that's a proper use of an expert to set the tort standard of care. And we've got law on that as well. For the expert to come in and say the standard of care, you are negligent. Experts don't opine as to what is negligence. And they don't set the standard of care. That's for
Well,
the
you don't
common law.
have anything rebutting that, do you, Mr. Roadhouse?
No, but you don't need an expert to rebut a non-expert opinion. And what I'm saying here is that's not the proper use of experts to come in and just try to establish the standard of care.
But I think, and Judge Redford can correct me if I'm wrong, the point of the expert is because the rest of us don't understand how these tanks work. And to say that when the whistle isn't being sounded, something is wrong. I don't think that goes to the ultimate determination of negligence or not. But again, you guys didn't have anybody say, oh, well, it could be any number of things. It wouldn't just be necessarily this, or maybe the whistle was broken, or he couldn't hear the whistle very well last time. So I don't think it's an expert who's determining negligence. It's just an expert who's trying to help us with how do these tanks work?
Right, but I think that's what they're trying to use it for. And the other thing here is that it has to be in accord with the testimony and the facts. And our representative that made the delivery testified to the slow fill and the fact that meant there was no whistle. And what we know here is that you had a successful delivery in November in the absence of a whistle. And then the whistle would have made no difference in January.
I thought he did hear the whistle. It was very faint.
No, I don't know that he said that, but certainly what made him stop in November was that he saw leakage out of the.
Yeah, oil's coming out of the vent.
Right. But there's also a testimony that that's not abnormal. That's
No, stopped in November when he didn't hear the whistle. Fortunately, there wasn't a disaster like this time.
No, but-
It's not that complicated an opinion from the expert. We have this ancient thing the Romans probably used. There's a whistle in a barrel, and when you don't hear it, it means it's full. So if you don't hear it, he should have stopped. It's not a controversial or really debatable.
But I think it is. I think the
expert
facts of this
opinion on
case
it.
undermine it because we had a successful November delivery without incident.
Well, it could have just been luck. That's like the guy that says, I always drive 80 miles an hour down my street. I haven't hit anybody yet. Well, that was just luck. Doesn't mean you should have driven 80 miles an hour down the street,
But
you just
under
didn't kill somebody.
I guess I would ask then, is the presence of, if you hear the whistle, is that a green light? Because in that case, it would have made no difference in January. Because it would have just been tooting along. It was still displacing air.
There's one and one only safety device that can alert somebody filling this tank as to whether it's full or not, correct? And that's the whistle.
I mean, he didn't overfill it in November just by observing, by watching it. Looking for it to stop.
Sorry. I clicked
That's
on
the
that
whistle
part.
from,
That's it.
that's the video of the whistle.
It is. Sorry. I was clicking at something else on your briefs. and
That's okay.
it Came up, so.
Okay.
So I can't agree with that. I can't agree with the comment that that's the only way. Because we know from the November delivery that he didn't have an
I'm talking about
incident.
safety
Right,
devices.
but I'm honestly a little confused on your response to Judge Kelly. What difference does it make that when he topped it off in November, which was like less than 50 gallons, it was like 10 or 15 gallons, right?
I thought it was 90, but
Okay, all right. So, but way less than goes in January. Whether he hears a whistle or not, how is that relevant to, he puts 200 plus gallons in first part of January, doesn't hear a whistle at all. How does that not at least, maybe you win the case, but I mean, how do you not have to try it? How have they not at least put in some evidence that a reasonable fact finder could find that your clients were negligent in the performance of their duties?
Because he testified that the absence of a whistle did not necessarily indicate a problem based on his experience there the first time. That with
Right,
a
and they
slow
have
fill, it
somebody
doesn't-
who says it absolutely is a problem. And at the C10 stage, the trial court is obligated under the law of Michigan to accept all facts in the light most favorable to the non-moving party, implying all reasonable inferences in favor thereof. I mean,
Well, because he's a not, well, who they have saying that is not a fact witness. He's not there. He hasn't dealt with this. He's an expert offering a testimony of what the legal standard should be and that it was breached, which I submit is a bridge too far.
understand.
But what no one has answered is that if there was a whistle working the way they say it should have, it would have tooted all throughout the January delivery until about the same time as when our representative was alerted to a problem as it actually played out, when we got to around the capacity of the tank, because it was still displacing air. You see my point? It was still taking the fuel the whole time. So if you had a whistle tooting along throughout that delivery, he's not clued into that there's a problem anyway, until you get to beyond the capacity of the tank, which is what happened here. He realized what tipped him off that there was a problem was that it had taken over 275 gallons.
But that's the whole point of the whistle.
But there
So-
it wouldn't have stopped. There
You're
wouldn't have
saying
been
the
a
whistle
222.
because there was whether it was the bung of the tank or the gauge of the tank, that blew out at some point, and that's where the oil escaped. And since the oil was escaping the whole time your guy was filling it, the whistle's still going to be going.
Never gonna stop. Or I mean, it was maybe not never, but not in time to do anything if it had been there the way they're saying it should have been.
But if it's what you're saying, that the whistle should have been going off, that assumes that the tank was empty when he came in January. But it seems to me that the way that it's going, because there was no whistle going, that the argument was that the new oil was displacing the old oil. You know what I mean? It's one of those sorts of things that if there's a leak, it's going to be empty. He's going to be able to fill it up. It's not going to be a problem, but it's the forcing the oil in and out at the same time. That's what I'm having a hard time grasping, but
Perhaps, I guess what I'm saying is there isn't really a factual basis to say no whistle, no fill is the standard.
but the expert said that.
Is that really what experts are for?
Yeah, yeah, they kind of are.
I think he's out of his lane at that point. It's to set the standard, the tort standard.
No,
Again,
they
I-
don't set the standard,
But he's saying the standard to care, no whistle, no fill.
He's only confirming what the whistle was invented for. And from what I understand is what everybody knows who fills these old tanks.
Right, but our guy also had the explanation of why he'd been there November, the whistle's not dispositive.
He's got this curled
He
thing
didn't
which,
have one
which,
in November
which
and there still
fails
wasn't.
any
Right.
physics kind of analysis, doesn't it?
Well, no, I mean, we're having the expert come in and say, this guy's wrong. This fact witness is wrong. Because this is how it's supposed to work. And that's not really what they did. Because our guy that was there on the scene had the explanation. He was testified. He said because he talked about the slow fill. They're saying the slow fill's made up.
Right.
It's not made up. It's
Mr.
just,
Roadhouse, I mean, I'm perplexed. Your guys say this, their guys say that.
but their guy's not a witness. That's the problem. They brought him in to just say our guy was wrong.
He's on a witness list,
I mean,
right?
he's I'm sorry.
And he's
He's not a
endorsed.
fact witness.
Fair.
He's not a fact witness.
Have you made a motion in limine to exclude him?
No.
Okay,
Because-
and
because
so
the
they're,
case was dismissed.
they're on an endorsed witness list for a trial that is set before a trial of competent jurisdiction in the state of Michigan. There is a witness that says all the stuff your guy says is wrong. How do we not have a fact question?
Not a fact witness. He's a retained expert opining about negligence. He's basically giving a legal argument at that point.
Okay, I understand your position. I do.
More to say?
I don't think so,
Okay.
unless there's more questions.
No, I don't think,
Thank
I
you.
think we understand your position.
Your Honor, if I could direct your attention to page 10 of my brief, there's a photograph of the tank setup. There's no way the whistle would continue to go and continue overflow out of the top. It would stop. the whistle, the whistle extends about 4 or 5 inches into the tank. And that's to prevent, the tank, when you fill it up, is not filled up to the top. If that makes sense. It's filled up till it hits the whistle, which is about 5 inches. I think it's about 5, 6 inches down into the tank. So there would never be a situation where oil would be continued to be pumped into it and the whistle would keep going unless there was I guess a hole in the side of the tank or a hole at the bottom of the tank or some situation like that. But I can't even imagine that, because then the problem with that argument is after this loss was discovered and the cleanup started, the tank was 100% full. They had to empty the tank, which means it wasn't a leak at the bottom. It was coming out of the bunghole at the top, which means they overfilled it so the whistle couldn't activate. So you would never have a situation where opposing counsel states in January where he would continue to pump the oil and the whistle would keep going and never stop. It couldn't happen. It wouldn't be going out of the tank then, because the tank has to fill at some point. So
What was the state of the float gauge on discovery of the problem?
the gauge, it sits in on top of the tank, like in a glass thingy. It was popped up, and we don't know what the explanation of how that happened. The expert opined that it could have been after the November overfill, the oil in that was still in the pipe coming down, which is probably 15 or so feet, had enough pressure and the tank was overfilled enough that it popped it out. So the oil was probably right at the level of that bunghole until they came back in January. And as they pumped, he pumped 285 gallons of oil that day. As soon as he started pumping, of course, there's no whistle and it's flooding out. And the sides of the tank were covered with oil when it was discovered. And the only reason he stopped pumping is he felt like it had been a long time and went and looked at the truck and saw he'd pumped 285 gallons into a 275-gallon tank and overshot it for sure 10 gallons at the very least on that day. Still, they didn't notify the homeowner or say anything. He came up, it was almost a month later that he got up there and found out the problem. He thought maybe that the person he hired to winterize it didn't winterize it. The furnace was still running. But I mean, I would say they had a duty at that when they overfilled the 10 gallons to at least notify, hey, 10 gallons is a lot of oil. I mean, it's something you don't, I mean, if you spill 10 gallons of oil at the gas station, at the point you go and notify them, they bring out the, hazardous waste people to clean up the spill. It's a big deal. And at a residence, it's a huge big deal. I mean, it can leach down into the water system and whatnot, but anyway.
Okay.
If you have any further questions, I'm happy to answer them. Otherwise, I appreciate the court's time.
Appreciate both of you.
Thank
Thank
you.
you.
Okay, thank you.
Happy
That
December.
concludes the 10 o'clock call. We'll take a recess here and be back out in a bit. Good afternoon. By about a minute here, we will begin our 11 o'clock call with item number 22. Item number 22, docket number 373357, State Appellate Defender Office versus the City of Grand Rapids. Have you worked out who's arguing? Okay.
I think I'm 6 seconds into being able to say good afternoon and may it please the court. Mark Magyar on behalf of the State Appellate Defender Office. As the court knows, this is a FOIA case, and what we as the appellant are asking for is a reversal and remand of the circuit court's summary disposition under C8 ruling in favor of the City of Grand Rapids. As we've stated in our brief, there's a couple of ways. I think the home run or the win we would be asking for would be a reversal with a finding that the exemption does not apply and to turn over the names that are listed in these incident reports. However, I can certainly see where the court may deem more appropriate a reversal and remand for the sake of just going beyond the pleadings and having a FOIA case and looking into some of these issues that I want to address today. So those are sort of the alternatives. Of course, there's, like I said, the home run, but we could also see where it may be more appropriate to just have further proceedings. And where I'd like to start, if the court will just indulge me for a moment, and I'm going to try to not repeat my briefs, but I think what got muddied a little bit below is sort of the very standard and clearly set framework that we go through in any FOIA case, which is you look to see if there's public information being requested. We have that. There's no dispute. So if that's the case, you look to see whether an exemption applies. A city or a municipality never has to, it's discretionary, but can invoke an exemption. And here they did. So if the exemption's applied and the requester doesn't agree, you make an appeal. We did, that was denied. So then you go to the circuit court. And at that point, our rules of civil litigation apply, the pleading standards apply, we state a FOIA claim. At that point, we know that it becomes the municipality's burden if they're claiming an exemption to meet that burden, that the public policy of the state is in favor of broad disclosure, and that exemptions are narrow. And in this case, we initially had the assertion of, I think, 5 exemptions. I'll skip through that because as the court knows, by the time we got to briefing, we were down to 1 claim of an exemption, the personal privacy exemption. And that personal privacy exemption has 2 prongs. You have to meet both of them if you're a municipality for that to apply. And the reason I'm going through this is it isn't till we get to the very bottom of this framework on prong 2 of the analysis that says you have to meet FOIA's core purpose, which is that your request is sort of meeting the purpose of the preamble, and that if it does meet that purpose, you go through the balancing. And I think where the circuit court and the city, really put a lot of the emphasis is on purpose, as if, Sato should feel sheepish about saying, yeah, our main purpose here is to obtain some information that we think is going to help our client. And I would say it's not the only purpose, but I think it's a little bit unfair to almost have to feel sheepish about that purpose, because I would suggest, Your Honors, that in almost every FOIA case, you never get to purpose. It's not, if you're seeking public information, you turn it over. The law is clear. Purpose is not relevant. It's only when we get through all the way to the bottom prong 2 of this analysis that we start to look at purpose.
But I think it's really important because FOIA can't be evaluated in a vacuum, right? Because the second prong talks about whether the public's understanding of the city's operations and activities would be significantly benefited. So we're talking about the public, not just Sato, but the public, if the public became aware of the names and identities of the witnesses. I'll tell you right now, I'm not seeing how the public understanding of the city's operations and activities would be significantly benefited by being aware of the names and identity of the witnesses in these reports. So
Thank you, Your
can you
Honor.
convince me?
I would like to address that. First, I'm going to address you head on, but then I'm going to say that we never get there. For lots of reasons, we cannot get past prong 1, and I do want to address that, but I don't want to skirt the question. I think in this case, we are dealing with a circumstance where after a cold case of over a decade, an individual was convicted of first-degree murder on shell casings. This is not a DNA case. So I think that the request that is made necessary, and it may turn out, we are not suggesting that we are saying GRPD did something wrong here, that their investigation was improper. But I think certainly when you're talking about the inner workings and when you look at why there was a core purpose in the ESPN case, for example, and that was investigating crime on MSU's campus, that we're going to.
That opinion suggests, I think, were individuals who were committing the crimes, collegiate athletes being treated disparately from other individuals. It wasn't going to who are the victims.
Yeah, I agree,
Right.
Your Honor. I don't think it's a 100% apples to apples, 1-to-1 comparison.
I'm not sure it's not apples to rutabagas. I mean, it's very, very different set of circumstances.
Well, I think we do believe that at least who the GRPD is talking to, the identities in that community could shed some light on how this cold case came to be a first degree conviction after over a decade based on shell casings. We do believe that. But I think though, that our real problem that we believe, or what we believe is a problem of focusing on that, really comes in under prong one. And because again, as the court knows, you don't get to this whole purpose question, core purpose, unless you've got both prongs. And I would respectfully submit that finding that the names are in a report of quote serious crime, as the circuit court did. We have 10 reports, all different crimes. Even if we accept that every single one of them is a quote serious crime, that is not ever enough on the pleadings to conclude that that is an item of information, that the name is personal in nature under prong one. And there are a few reasons for that. Number one, I think that when we look at precedent, you have to look to Ratage to look to what the default rule is that names in a report standing by itself, absent special circumstances, is not exempt, okay? Now, ESPN and State News both said, but if your name is in a criminal report, then it might be, to use Ratage words, a special circumstance. So that's not the end all be all. That's the first step in saying, are we going to get out of Ratage? Are we going to find an exception? Are we going to find a special circumstance to then say, in this special circumstance, it is personal in nature? And the reasons, so let's look at those cases. State News was a case where the entire report was blacked out. And the court said, no, you have to do better, municipality. You have to at least make it an examination of what can be pulled out of there and what can't, and turn over the non-exempt information. And
Which is not what this case is.
correct, that's not what this case is. But what they did, but it is a case we're contending is it is still a case where you can't just make a blanket rule for 10 reports. You have to look at each report. So if you can pull some out from some reports and some than others, then you have to. And that's even, I think, a fair reading of State News. But also then ESPN, and by the way, State News ended up saying, we can't determine if these names, they might be personal. We can't determine because the entire thing was blacked out. That's not this case. So then ESPN builds off of State News and says, names in a police report might be personal in nature, and you would have to make a particularized finding. Again, we're only talking about one report there, but we don't need to get there because in ESPN, they say prong two is satisfied and disclosure is required. So the case law has developed, arguably in dicta, but I'm not suggesting this court shouldn't look at ESPN, shouldn't look at State News. There has been over time some development that under Ratage, you produce names. There might be special circumstances, including in that special circumstance might be that you're in a criminal police report. But then we look to why being in a police report makes it potentially personal in nature. And some of those whys, I would respectfully submit, cannot be determined by reading these reports, whether in camera or redacted. And some of those whys are, is there a risk that the names are going to fall into the wrong hands? Is there a risk to the physical safety? Is the request being made by a requester who has a certain personal agenda or motivation that they want this personal identifying information that is unique to the name of the person being redacted?
But that's putting the emphasis on the person who's requesting the information. And I don't see that as being the really relevant inquiry here.
I think under prong one, it has to be.
But maybe I just missed reading that part in ESPN or the State News.
Well, I think when the questions are being asked, even the circuit court in this court case noted, at least at the hearing, that maybe the 18-year-old at that point, 19-year-old, I guess at this point, a distance back of the crime could have lessened some of the risk of personal safety, which goes directly to whether this names are personal in nature. And some of the other questions I would pose that we don't know on this record are, which of these 10 reports resulted in an arrest? if no one was ever arrested and there's nobody out there harboring a criminal who says, you know, I'm going to seek retribution if I find out who was in the police report, if there was no arrest, I think in those cases, then that risk would go down. And then what about a conviction? If we have someone,
Why is that?
so
If there's, you
So
have
let's say
an
we have-
unsolved,
we have a police
criminal
report.
act.
We have a police report and my name is in it. And I'm worried if my name gets released, a criminal is going to come seek retribution.
Okay.
But then
And the crime's never solved, and
there's-
you have less risk because the crime's never
there's
solved?
there's no one out there walking around saying, I got arrested because of this rat, Mark Magyar.
No, now there's a guy who hasn't been arrested that knows, hey, this guy is cooperating with the police.
If we assume that an 18-year-old report in a case that didn't lead to arrest is going to lead to someone finding that out because of this disclosure that may then be upset about it enough. I mean, those are a lot of links to say that not only are we getting past C8, but now we're past the pro-disclosure policy of the state, and we're past the narrowly construing exemptions. I mean, those are so many inferences that I think we might as well say then this rubber stamp of being in a police report is now the law, that's always personal in nature. And I don't think that's what the law is here. And like I said, if we remand, it could be that the city prevails. I don't think we have a record to say that we can do that on the pleadings and not ask and look into these questions, which also include, even besides whether there was an arrest, whether there was a conviction, is the witness the name that we want? Is it someone who's alive? We cited the case where you don't have a privacy implication anymore. I don't think we can overlook that we are dealing with 10 reports. We're not dealing with one report. So it's not good enough to say they all involve crime, case closed, C8, we're done. What about in this case where the witness's name who's redacted is not alive? Or in this case where
What about, I mean, you want to talk to live people for information about your
If
client. I
we-
mean,
if
dead
we-
men don't talk. So what good would it do if they're dead?
that could be the first stepping stone. I mean, I think most of your honors have all been trial court judges. I mean, you find out one piece of information, you can learn other information. And I don't think
It's from a name of whether somebody's alive or dead?
it could. And I also don't think that detracts from FOIA, that it being an item of personal information that we don't believe is properly subject to an exemption, and certainly not on the C8 standard. So, I mean, I guess the questions you're asking are fair questions, but I think we always got to keep it under the umbrella of what we're talking about, which is FOIA and public information and pro-disclosure, and that the why doesn't really matter if the city doesn't meet its burden to establish that the exemption applies. And I would note, I mean, I think Sato has at all times in this case acted in utmost good faith. I mean, we could have kept our claims to the other 13 reports alive, but once we started getting the production and seeing, okay, what we really care about is these 10 reports, we voluntarily dismissed those claims because I think the city would have been facing, I mean, Judge Benson wasn't even willing to grant summary on those because they weren't prime. And I think what we haven't addressed so far
Well, if
is.
you hadn't done that, you wouldn't have an appeal of right either.
Right. I mean, we could have kept litigating and we could have maybe gotten those names, but it would have been, justice delayed in our minds. But I think, I'm not trying to get disjointed here, but I think that calls into another whole question that that Sato, I think, would hope that this panel addresses, is that this sort of after the fact, there might be a justification for the redaction, such as personal privacy, isn't a basis to have an internal policy of anytime we get a name in a police report, it's, when in doubt, black it out. I mean, that's not what FOIA is. And I think we have a pretty clear record without a lot of dispute that was the approach for all 23 reports. And that was just by the grace of, applying ESPN, look that at least there was a plausible argument for the ones in criminal incident reports. I still, for all the reasons I've said, do not think you can stop at the fact at 10 different reports that just because they're in a report that involves crime, you have gotten out of Rataj, you've gotten into ESPN, and you have a black letter rule that now this is personal privacy. I think you do have to look, or else, why in all of these cases we've cited, are they looking to things like, oh, in one case, they wanted to know about gun ownership. In another case, the woman, this is the city's case they cited in their response, the woman who leaves her optometrist appointment and is driving erratically, and she gets turned in by a retired state police officer, and then she wants to know the identity of who turned her in. These are things that are and to your question, yes, it does matter the identity of the requester in those cases, because it goes directly to prong one of personal privacy. Is it personal in nature? And that is informed by different facts and circumstances in every case. And sometimes it is the identity of the requester because it shows that they're being put at risk, or they're seeking it for a personal reason or a personal identifying reason. And I think that's why you can't, on a lump 10 report basis, say just being in a report that the circuit court deemed serious crime is enough to rubber stamp a C8 exemption. We have to look at, and this is why, to go back, why I think the state news analysis is applicable by analogy, is that even though we don't have a fully redacted one report, the real emphasis in that case was you can't lump everything together. Just because you find some exempt information, you have to make individualized findings to parse out which can be produced and which can't.
But isn't that what they did? I mean, they didn't get rid of everything. They just got rid of the names.
Yeah, they got rid of, and that's how I'm analogizing. They got rid of every single name across all 10 reports for the reason that they are just a name listed in a criminal police report. And that's the kind of failing to parse out to see if all these other considerations that the case law support. I'm not making these things up when we talk about whether there's physical safety concerns, whether there's falling into the wrong hands, whether the requested information is based on the personal identifying information like gun ownership of the witness. These are all things that you have to delve into to see if what you're really dealing with is information of a personal nature, because being a name in a crime report is not enough, is our position, and that we don't have a record on C8 to conclude that the exemption applies. And that's why I'm not trying to avoid prong two, but I think that's really where the fact question is on prong one. And if that's a fact question, you don't get to prong two. Until you meet prong one, we don't care what under FOIA, what the purpose of the request is. It's public information. And if prong one isn't met, there's not an exemption to withhold.
You got about 10 minutes for a rebuttal. If you
Thank
need it.
Good morning, Your Honors. Elizabeth Fossil on behalf of the appellee, the city of Grand Rapids. I have to thank Mr. Magyar for actually saying that Sato does not suspect that the GRPD did anything wrong in their investigations. I usually hear the opposite when I'm up in front of any court. So it was delightful to hear that today. I am a little mystified that he is focusing on the issue of whether or not the witness names and their addresses in these reports are personal information. I'm sure the court has had a chance to read the transcript, at which time Sato's attorney at the hearing before Judge Benson was discussing the issue of whether there's a shooting and whether or not names in police reports of a shooting are personal. And Mr. Vandegrift, who was then the attorney, said, I agree. I think the first prong is met when you have a shooting and you have a witness in that report. I think that's information of a personal nature. I think we're done with that issue. But even if we weren't, ESPN made it very clear. I know counsel would like to consider it dicta, but it's been quoted in a number of cases. ESPN said, quote, if I can find my quote, it would help. Here we go. While the name itself does not provide information of a personal nature, the context in which the name is used may. And with respect to names contained in a police report, the court stated, quote, just being linked with a criminal incident is information of a personal nature, end quote. And the court reasoned that that's because people, quote, people linked with a crime have an interest in not sharing this information with the public. That's ESPN at 667 to 669. I think that under the circumstances of this case, where the court had all 10 of the reports we're talking about today, because Sato included them in their complaint, and the court could see where the redactions were and the body of the narrative of the complaint, that the court had the basis it needed to make a determination under ESPN whether or not that information was of a personal nature. ESPN, personally, I think ESPN and the Molloy case should guide this court. ESPN gave us a framework for dealing with police reports in particular. ESPN said, quote, in order to protect the privacy of the person named in the report, a public body might redact the information of a personal nature associated with the named person, or, as was the case here, might redact the name of the person involved, but leave the information unredacted. That is precisely what the city of Grand Rapids did in this particular case. It took out the names of the witnesses and their addresses. It left the discussion of their statements. It left the investigative actions of the police and the names of the police officers intact in those reports. So it separated out the exempt from the non-exempt information, which is what required by the law under FOIA. I think the circuit court did exactly the same thing. It reviewed the reports, again, which were attached to Sato's complaint. It concluded that each report involved serious violent claims. For the most part, these were shootings. That's about as violent as you can get. And it concluded that, quote, each person listed in the police reports, whether a suspect, victim, or witness, risks being associated with a type of crime most feared by citizens and police alike, end quote. The court therefore properly determined that the witness names were personal information and under the privacy exemption.
You think the court was?
I'm sorry, Your Honor?
Do you believe, Ms. Fossil, that court should have undertaken an in-camera review of these 10 reports in addition to whatever the review of the narrative that was available?
Thank you for that question. The court did review these reports in camera, number one. Number two, if it hadn't, I don't think we'd be in the same position we're in now. But because it did review the reports and the only thing that's redacted are the names and the addresses, an in-camera review further is not going to change this result. How would the addition of the names in unredacted reports change that result? I don't believe that it would. So I believe what the court did was adequate for the purposes of this case. With respect to Molloy, which followed the ESPN framework. In the Molloy case, the plaintiff made a FOIA request for a police report that, as Mr. Magyar said, documented the investigation of plaintiff for erratic driving based on reports of several witnesses. The plaintiff made a FOIA request. The police report was given to the plaintiff with the names and addresses of those witnesses redacted. And the interesting thing about Molloy, again, like the case here, is the narratives were completely unredacted. It was just the names of the witnesses that were
I have some
redacted.
passing familiarity with that case.
Yes, I kind of noticed that on the caption of the case. Yes, Your Honor. That's one of the reasons I like it so much.
I'm sure your opposing counsel is as enthusiastic. But,
let me just come back to the similarities between that case and this one here. In Molloy, the plaintiff, like Sato, sued claiming that the witness names should be turned over. The Court of Appeals found, first of all, that the names were of a personal nature because, quote, the witnesses might not want the fact that they were that they reported suspected
but in
criminal
Molloy,
activity
the
divulged.
plaintiff was the FOIA submitter was saying, I'm gonna sue these people because they lied about me and I shouldn't have lost my driver's license or driving privileges. I mean, so it was a very specifically articulated basis that was before the trial court at the time. We don't have that same precise, well, there's no threat at all that's knowingly before the trial court, when the trial court would upheld the holding back of the names in this case? Why doesn't that make Malloy not as important?
The passage of time doesn't change first of all, I don't think that there has to be physical threat. Under ESPN, the mere linking to a criminal report is enough to make it personal information. That's what ESPN says. If there's a physical threat, that heightens the problem. In this particular case, we're looking at people who were around 18 years ago who were involved in violent crimes involving shootings, one of which, as I recall, involved some gang member. In any event, at 18 years later, they're going to be questioned about their activities back then in connection with a violent crime that most of them had nothing to do with except being victims or witnesses. That's, in many respects, both harassing and embarrassing, and that's a basis for determining that it is personal information. I think the fact that we might have Sato knocking on people's doors after 18 years and asking them about crimes that they may have no memory about, or they may be completely traumatized by, who knows what their situation is asking too much of that individual under these circumstances. If there is any threat, whether it's large or small, if the responding party cannot determine the nature of the threat, Sato would say then that responding party must turn over those names despite what the threat might be to the individuals. I think the court needs to err on the side of caution in protecting the individuals under those circumstances. I think that's the better course of events. I wanted to point one other thing out about Malloy, and that's with respect to the second prong, the balancing test, which I know Mr. Magyar did not focus on too much, but Malloy is very instructive in this. Malloy said, in the present case, the names of the witnesses who reported plaintiff's erratic driving would reveal nothing about the operations or activities of the government. Plaintiff was given all of the information by defendant about the witnesses' statements, and this is all plaintiff needs to understand the officer's response. In other words, that's all that is needed to understand the operations and activities of government under FOIA, which is the core purpose of FOIA. I think there's a reason that Mr. Magyar focused on personal information versus the second prong and the core purpose of Sato, because the core purpose is served by getting the narratives of these police reports, which was precisely what was done in this particular case. So I think the similarities between Malloy, which is an unpublished opinion, but the rationale I think applies very, very well in the case at hand, ESPN and a number of other cases that have held that third-party information is considered personal information and not disclosable under FOIA when there is no core purpose, or the core purpose does not significantly outweigh the privacy interests which the legislature wanted to protect. I think that's where we are in this case. And I'd be happy to entertain any questions the court might have.
I don't think so.
Okay.
Any questions about Malloy, Judge Redford?
Not right now.
Okay.
If anything comes to me, I'll
Thank you
ask
very
either
much.
in this case
I
or in the next
appreciate the
one.
court's time.
Thanks for the opportunity. You could probably explain it far better than the panel, I'm sure. So.
Thank you. Just a few points I want to address. We addressed in our reply, but this notion that there was an agreement by my colleague, on the appellate counsel, but my colleague, it is not a fair reading of the record. You know, we've argued since the complaint, since the briefing, everywhere, that the first prong is not met. And as we briefed, when you look at the context of the discussion, Judge Benson said to Sato's trial counsel, he said, now under ESPN, and he framed it in the context of ESPN, that names are, or can be, private information. And what my colleague did was say, okay, yes, I agree. As in, I agree, that's what ESPN says. And he steered the conversation to then saying, even if we accept that premise, this is all just oral argument, even if we accept your premise for the argument's sake, then prong two isn't satisfied. That was how that conversation went. So the notion that there's like some binding agreement or admission that all of these names and all these 10 reports that we're talking about today are personal in nature, is just flatly rejected.
Ask you a question.
Yes.
If you have the names in the reports that you have in your possession, of the officers, why isn't that enough, at least to get the process started? I understand whenever you're doing an investigation, you always want as much information as possible. So ideally, you would want everything unredacted, but don't you certainly have enough to, really make a firm go of it as far as who to talk with? And then if you need more, then you could go back to the court at a later time and say, or to the city and say, you need to supplement this, and here's why. We talked to officers A, B, C, X, Y, and Z, and they say this, that, and we need to know in these 5 cases who these witnesses are.
Thank you, Your Honor. That's a practical approach that I wish I was more equipped. I'm a civil litigator. I'm not SATO. I don't pretend to know how they go about their investigation, and I would never pretend to dictate that for them. Some of my assumptions are that they may just run into other forms of exemption. You've got, law enforcement investigatory. I think at one point that was asserted.
Ongoing investigation. There is an exception that I have addressed in the last few years on the Court of Claims. And if it's an ongoing investigation, then law enforcement will often assert that.
Yeah, I guess my point is, regardless of any particular exemption, there's in my mind, a fair reasonable likelihood that you're just walking into that fight first. And whether you prevail or not, then, once you get through that, then you see if you have enough information. I mean, it's just.
And the sky is blue in the
Right.
the world I live in. So I understand the law enforcement officers may say, yeah, no, thank you. We don't want to talk. I get that.
Right. And I think it's still, and I don't want to just beat the drum of, well, we just get it because it's public, but we are talking about FOIA and public information where, while I think it's important to have these sort of academic conversations, doesn't really take public information out of being public information for purposes of the statute. And, if that's what the request that say.
Your position is we don't have to do that. It's public. They got to give it to us.
Yes. And I do want to talk a little bit more about ESPN. I mean, even the circuit court, who ultimately sided with the city, said that case is not as black and white as the city is saying. That's in the transcript.
Can you talk about the second prong, please?
Yes, absolutely.
I mean, Judge Benson's analysis is pretty extensive with respect to how he views the second prong. So
right. And I think just for the same reasons that, Sister Counsel, Ms. Fossil pointed out that we have been mostly talking about prong one. I think that's exactly why the city was mostly talking about prong two, because I think they have a much harder time on prong one and want to steer it towards prong two. And we have you have to have both prongs.
But that's what I mean.
Right.
So but I understand what their position is, but with your position, because I'm still not seeing. and
Our
the court was
position
not-
remains that.
How did the public disclosure of the names constitute, go to the core purpose of
Yes,
FOIA?
our position remains that when we are looking at the inner workings of the GRPD, including the identities of who they chose to spoke to in an over decade-long cold case where the first degree murder conviction of Mr. Brown rose or fall on shell casings, not DNA. This is, if you think about it, going to prison on first degree murder off shell casings is over on a cold case is a significant development. This is not a DNA case. That's usually what you hear about cold case and murder convictions. So who they talk to, we believe could absolutely shed some light on the inner workings of the GRPD and how this result, which in Sato's mind and Mr. Brown's mind is an absolute travesty, how that resulted. And that's our position on prong two, Your Honor.
But how do you square that with the published case law of Michigan that says words along the lines of, let me get to it. In determining whether to withhold information under the privacy exemption, a state agency should not consider the requester's identity or evaluate the purpose for which the information will be used. See State Employees Association versus Michigan Department of Management and Budget, 428 Michigan, 104, 1987. Also, Case law is clear that initial as well as future uses of information requested under the Freedom of Information Act are irrelevant in determining whether the information falls within an exemption. See Taylor versus Lansing Board of Water and Light, 272, Mishap 200, 2006.
I agree with everything you said, and I don't think we're
Okay.
trying to argue outside of that.
Well, it sure kind of sounded like you were just a second ago.
Well, let me try to explain. On the second part that you said that the purpose is not relevant, that's extremely helpful to my case because you only get there if you get all the way down to court to the second prong. Every other question about whether it's public information, whether prong one, purpose is irrelevant. Now, when you look at the
This is requester.
well, and when you get to requester, I think it's a little bit more nuanced. What we're saying is just, oh, we're not saying our identity is relevant to our request. But if you're going to say, if you're the municipality bearing the burden and you're going to say that the reason that this information is personal in nature is because, now look to the case law, it's going to fall in the wrong hands. Well, what does fall in the wrong hands mean? Just like your Malloy case, Your Honor, it means the identity of the requester impacts the analysis of whether the information is personal in nature or not.
The
That's the
requester in
nuance.
Malloy said, I'm going to sue. There was an open declaration beforehand, before the trial tribunal made the decision it did that we affirmed.
And in another case, the requester was a private company whose specialty was purchasing winning lottery tickets at a discount, and their information sought the names of people who won the lottery in the last decade. It was the identity was important to determining whether it was requesting, quote, personal in nature. It was only relevant because of the exemption asserted by the municipality and whether prong one was satisfied. It wasn't, the identity was not otherwise relevant in any of those. And we're not claiming it is here in terms of our request. But when you're looking at, is the information going to fall into the wrong hands? Is the safety at risk? Those are all fact questions having to do with prong one that implicate whose hands it's falling into, whose hands is the information falling into. And on that point, I did want to talk about ESPN a little bit more because I actually agree with my opposing counsel that ESPN sets a framework, but I think we disagree on what that framework is. In that case, there's a quote from ESPN that says, but in this case, we don't find it necessary, and I'm paraphrasing because I don't have it right in front of me, but I quoted it in my brief. We don't find it necessary to make particularized findings talking about whether these names, that there are other factors making it personal in nature. Because so the case never got to the point that we're saying has to be done here, which is, okay, you've met step one. You've met the fact that these names are in criminal reports, but then ESPN talks about a next thing that court never had to get to. It talks about making particularized findings. We have 10 different reports. And there were comments by opposing counsel about, well, these all involve shootings. We respectfully request that that's making our point for us. Some of the shootings were stray fire into a house that has no other connection to the crime. Some were the victim. These are exactly the particularized findings where the name in police report number one might be absolutely personal because it's the victim and the criminal is, hot to trot to go after him. Whereas in this case, it was a stray bullet in a case that they never found, not likely to ever get into the hands of someone who would harbor some ill feeling towards this witness. I mean, we have 10 reports here. There is not a way on this record to say that particularized findings, just because there was crime involved, has met the C8 standard for whether some of the names under Rataj should be produced as being public information.
Got about 2 minutes left.
I thought there was a really interesting statement by my opposing counsel that said she believes that this court should, quote, err on the side of caution of protecting individuals. I think that's what the city did. I think we saw that they redacted every single name in 23 reports, irrespective of whether there was a crime or not. And I think that asking to do that is directly contrary to all the law that is in my brief of how the framework that I started this day with operates. We don't look for ways to err on the side of redaction. We look for ways that the municipality met their burden to say that an exemption applies to otherwise public information that is, if you don't meet your burden, it is produced. And so I think that statement shed a lot on both the approach that the city took, the approach that the circuit court took, and why we should at least have beyond a C8 case here.
Right. Thank you very much.
Thank you.
Thanks. Full
That
counsel.
case will be submitted. Next is item number 23, docket number 373417, American Civil Liberties Union of Michigan versus the City of Grand Rapids. Once again, have you worked out who's arguing? And okay, the whole thing? Yep. All right. And
Not only is he here, but so is his client. It is one of the really storied lawyers of West Michigan. So I wanted to say good afternoon. You can't have it. You've surrendered it.
In case there were any questions about
You
the
can
record.
file a report and a FOIA request to see what we did with it. Thank you, counsel.
Good morning, Your Honors. Ben Vanderwerp on behalf of the ACLU of Michigan. As you mentioned, Judge Rochford, I'm here with Peter Armstrong. We also have
One of the legends of our bar.
Yeah.
Mr. Armstrong, good to see you.
I've heard great things. We're also here with Miriam Ackerman, who's senior staff attorney for the ACLU, and I'm also joined by my colleague, Robert Bradley. This case asks whether Michigan's FOIA guarantees a meaningful, timely right of access, what the statute calls a reasonable opportunity, or whether public bodies can effectively nullify that right through administrative delay. The city took 13 months to complete a 3.5-hour request. According to the city, that delay, and presumably any delay, is okay because it has no obligation under the statute to timely disclose public records at all, even if that delay undermines a requester's right of access, and even if it undermines FOIA's core purpose of self-governance and government accountability. The circuit court agreed. This is not reasonable under any rational interpretation of the statute and contradicts this court's prior precedents. The circuit court's narrow reading of FOIA's disclosure provisions strips them of their purpose and should be reversed. First, FOIA's text, structure, and purpose require that public bodies provide access to requested records within a reasonable time. Reasonable opportunity is mandatory, not discretionary, and therefore must mean something more than eventual access.
But how do you handle the fact that certain organizations, City of Grand Rapids, City of Detroit, that they have a lot of FOIA requests? So if they have all these FOIA requests and they have one FOIA department, because I don't know many places that have multiple FOIA departments, how do they say, well, your request, because it only takes 3 hours and 30 minutes, jumps to the head of the line when we have all these other ones that have just come in? That doesn't seem to be required under the statute.
I agree that it's not required to have any particular request jump to the head of the line. And frankly, I think that's sort of a red herring in this case. What we're arguing is that 13 months, a delay. Now, the fact that it was only a 3.5-hour request, I think shows how stark the delay is.
Yes, but again, if you're still, it's like us trying to get cases out, right? We want to get cases out as quickly as we can because a lot of these cases are very important. There's trials coming up. There's other things going on. But we have this backlog of cases that prevent us from quickly getting your case out, even if it might be a simple case. There's only one issue, right? And we should be able to resolve it pretty quickly. Question of law, let's get it done. But
Right.
we can't because we have a backlog. And I don't think that you've addressed the fact that the City of Grand Rapids just can't say, oh, because the ACLU filed this, or SATO filed this, or Joe Schmo filed this, we're going to put them at the beginning of the line and forget all the ones that we have pending. Because I mean, was there any evidence of the fact that they just sat on it? They just kind of put it under their chair and thought, oh, we're going to make them wait. We'll make them twiddle their thumbs. Or is there evidence that, okay, it just got put into the queue, so to speak?
No, there's been no evidence that they just sat on it. And we aren't arguing that the ACLU or any other requester should be put ahead of the line of anyone else. The issue is that it's a 13-month delay is completely outside the bounds of a reasonable opportunity, which is mandated by the legislature. So that may be something that sort of distinguishes it from Your Honor's docket, right? The legislature has commanded public bodies to provide a reasonable opportunity of access to public records. We say that that must involve some concept of timeliness.
Right, but counsel, in the, there are a number of temporal benchmarks in the FOIA. As far as response, as far as the notice to the entity that's requesting of that you're going, that the governmental requested agency is going to take more time. So the legislature has specifically spelled out 5 days, 10 days, 15 days, whatever it might be for a number of things, but they haven't done that for the other aspect that you're seeking the relief for. How do we square that without writing, becoming the legislature and writing in the statute? Maybe a great idea, but do we have the authority to add that on to the legislative pronouncement?
So thank you, Your Honor. First, to just address the, how do we square it with specific deadlines for other aspects of,
Of the same statute.
in the same statute, right? And instead we have a reasonableness standard for the disclosure obligation. I think that makes sense because with respect to responding to the request, requesting an additional 10 days to respond to the request, et cetera, those apply sort of across the board, regardless of the request. There's not much about any particular request that's going to make it difficult to respond to provide an initial response in that regard. With respect to disclosure, that's where we get a panoply, a great variety in terms of the requests that are made. So it was reasonable for the legislature to put a reasonableness standard on that to account for the sort of competing interests of, well, we have a pro-disclosure statute. They should be promptly responding to requests, but at the same time, some requests are large, some are complex, some require inter-office coordination, et cetera, et cetera. So there has to be some flexibility on the part of the public body.
I have FOIA cases often, and my responsibilities in the Court of Claims. And I had, as a director of a state agency, was the person who signed off on FOIA stuff from time to time. And anyway, it's a challenging issue.
Yeah, and I don't doubt that. I don't dispute that. It's a tough nut for sure. Our position is simply the legislature has told public bodies through FOIA, both through its purpose and its structure and its text, that they have to provide a reasonable opportunity for requesters to examine records.
I'm assuming familiar with the federal FOIA statute?
Somewhat.
Okay. Do you recall whether the federal FOIA statute has specific time? Agency, you got to do it within 90 days, 30 days, 60 days.
It's my understanding that the federal FOIA also does not have a specific deadline that request must be fulfilled within.
That was my recollection too. I did Navy's FOIA for a long time. So, but I couldn't remember specifically. So thank you.
Yeah, no, similar to the Michigan FOIA, I believe the federal FOIA has strict guidelines around how quickly they need to respond and et cetera. And it may be more fleshed out a bit, I believe, in the federal FOIA.
Certainly probably in the CFRs, but
so I want to address first our textual argument. Our position is that the text, the structure and the purpose, and again, the purpose of FOIA is folded into the text. I mean, courts are required to read the text in light of the purpose. And we believe that requires public bodies to provide access to requested records within a reasonable time. When we read that together with a requester's rights and also a public body's obligations to provide a reasonable opportunity, we believe that applies regardless of the means that the public body decides to use to actually make those records available. And we think that that's one of the key errors that the circuit court made here. The circuit court essentially parsed the language of, on the one hand, you have a requester's rights, On the other hand, you have a public body's duties. And although a requester has a right to inspect, copy, and receive copies, a public body only has a duty to provide a reasonable opportunity for inspection and examination. And so therefore, because copies were received in this case, it had no obligation to provide a reasonable opportunity to receive copies. We think that that impermissibly adopts a narrow reading of the disclosure provisions. This court has been clear that disclosure provisions are to be read broadly, exemptions narrowly, and that FOIA just does not invite courts to narrow its disclosure provisions through sort of negative implication in that way. I don't think that the analysis makes sense anyway. The circuit court essentially it essentially created a logical mismatch within the statute itself. It recognized a right to receive copies while withholding the corresponding obligation to provide a reasonable opportunity to receive those. And then it conjured a duty to provide a reasonable opportunity for examination, even though examination isn't a listed right that a requester has under the statute. So the analysis really doesn't square with the text of the statute. And so interpreted broadly to effectuate its purpose, the duty to furnish a reasonable opportunity necessarily encompasses the means of access the statute authorizes, which are inspection, examination, copying, or receiving copies, however the public body decides to make those records available.
So what is a reasonable time? I mean, remind me, are you asking us to determine what it is, or are you just saying in this particular case, it's beyond dispute that this is unreasonable?
We're saying both. So in this,
What is the reasonable time then?
yeah. So what we've proposed are a series of factors that we've pulled from the statute, pulled from some case law, we think balance those in the interests, the pro-disclosure interests that are involved here, the overwhelming pro-disclosure interests that are involved under FOIA, and sort of balance those with a public body's obvious practical, the realities of actually responding to FOIA requests. So we're not saying the court has to adopt those. The court may think that there are other factors that ought to be considered. Maybe some of the factors that we identify shouldn't be considered, but we do think that this court is well positioned and should provide some guidance on what reasonable opportunity means in the statute. That's the peculiar province of the judiciary. The legislature said reasonable opportunity. What does that mean? And we again believe that it must have some concept of timeliness. Otherwise, reasonable opportunity can be completely undermined by delay.
I had a case within the last year that the governmental agency said it was going to take 5 years or some such thing to reply. And I was pretty straightforward about what my expectations were, and the case got settled surprisingly right after that. But there are remedies. I mean, you can go to the trial court and you can say, trial court, this is not reasonable. And sometimes you win and sometimes you don't, but
well, that's what we did here, Your Honor.
And the trial court said,
there is no timeline or timeliness requirement, is what the trial court said. And we believe that that's clearly wrong. So I think the trial court made an error of law there. There was no balancing of factors. There was consideration of the size and nature of the request balanced against, the city's backlog and whether that backlog is a sufficient.
was there evidence of what the backlog was? Is that a matter of record?
I believe so, yes. So the city, I don't have the numbers in front of me, but it was something like, in 2020, and I'm sort of paraphrasing, I can be corrected, obviously, but in 2022, we had 1,000. In 2023, we had 2,000 or something like that.
Okay.
And so you do see this gradual ramp up of FOIA requests over the course of something like 2.5, 3 years. Now, corresponding with that sort of linear increase in FOIA requests, you had an exponential increase in the amount of time that the city was taking to fulfill requests. So as you're seeing like a 50% increase year over year or something like that on FOIA requests, you're seeing the time it takes to respond to those requests multiplied by, tenfold, something like that. So it started out as, oh, we can do them in 7 days. Oh, now it's 30 days. Now it's 3 to 10, now it's 3 to 5 months. Now it's 8 to 10 months. Ours, of course, took 13 months for a modest request. So the position we're taking is that the legislature commanded these public bodies to provide a reasonable opportunity to access public records. That involves prompt, timely disclosures. And, we don't take, we're not quarreling with the city's process. If it wants to use a first in, first out process, maybe that's rational, maybe it's not. The issue is that they need to do something, whether it's allocating more resources, requesting more resources, whatever it is. Maybe there's changes to the process, whatever they need to do to get their fulfillment timelines down within a reasonable range. And so that clearly was not met here. And we would like the court to provide some guidance, both to lower courts, to requesters, to public bodies, as to what exactly is required in terms of timeliness to satisfy their obligation under FOIA.
Anything else?
Thank you.
Good afternoon. Sarah Hartman on behalf of the City of Grand Rapids, and I'm joined at council table by Kendall O'Connor from our office. I will also note that a number of individuals from the records unit from the GRPD are also present here in the courtroom. I'd like to start with council's discussion regarding the reasonable amount of time and what was testified to and is part of the court record. Michaela Smith, who acts as the FOIA coordinator for the GRPD records unit, did testify and has provided an affidavit with the volume of requests that were coming into the department at the time that this was relevant and the years leading up to it, and that the volume that continues. But it's not just the volume that's the problem. It's also the nature of the requests themselves. Council indicated that requests were taking longer and longer to process. That's because they have become more and more complicated as technology has led to more detailed and accurate information that is available through video and other sorts of use. Those complicated requests continue to increase. 2025 is looking to be another record year for the amount and detailed types of requests that are incoming. But beyond that, council is not just asking this court to find that the city was not reasonable in the amount of time that it took to fulfill the request, but they want their own definition of what is presumptively reasonable.
Well, let's start with the first one. 13 months seems like an unreasonable amount of time, doesn't it? For a fairly simple request.
In an ideal world, that time would be reduced, but with the staffing limitations and the volume of requests, the types of requests that come in, which the city has no control over, if they get inundated in one day with 3,000 requests.
But what if you reduce the staff to one person?
It's not one person.
Well, I know it's not, but what if you did? Could you then take 5 years to do it?
And
By
they've
saying
done that.
Well, it's just, that's.
And they've done that
reasonable
too.
Under the circumstances, or do the circumstances have to change to make it reasonable?
And the city has done that too. And in the testimony of Ms. Smith, it shows that the city did hire more. They approved overtime. So they have taken steps to try to get that number down. But as they take those steps, when they have new hires, for instance, those people have to be trained. It's not an immediate, they can step in and all of a sudden they're processing.
And I'm not
FOIA
suggesting they're
requests.
sitting around twiddling their thumbs. I'm sure they're very, very busy doing this, so.
Yeah. And that's part of the standard too, is whether or not the city has acted arbitrary and capriciously. That was part of the argument below, that they don't make, appellant does not make the argument that we acted in any sort of arbitrary and capricious manner. And the FOIA statute talks about whether or not a response is untimely in that kind of context, whether or not we're willfully and intentionally withholding information or delaying for some sort of willful or malicious purpose. And that's not what we have here. It's simply the mechanisms of government and the amount of time that it takes to respond to the volume of requests that they are receiving.
If there were a statute that imposed sanctions for not complying within a certain amount of time, seems to me that Grand Rapids would find the resources to do that. But maybe until something like that comes into being,
But that is asking for this court to legislate.
I'm not saying we're going to do that. I'm
Yeah.
saying if the legislature did that and imposed strict time limits.
Then the city
Would you
would
say we
make
just
all
can't
best
comply?
efforts to
Right.
abide by the statute, and they do abide by those strict timelines that are for responding initially with a grant or denial. And here it was a granted request. Those timelines were met. That's not at issue here. It's simply the fulfillment process that comes on the back end of granting a request.
Well, statute does have section 240 sub B that talks about willful violations, and it provides for penalties where a public body willfully and intentionally failed to comply with the act or otherwise acted in bad faith. The court may order the public body, in addition to any other reward or sanction, to pay a civil fine not less than $2,500 or more than $7,500 for each occurrence.
And that was what I was referencing as far as any sort of malicious or willful delay or intent to, not, or to withhold information. And that's not what we have here. That's not what's argued here. It's. Yeah,
I was
it said,
I was gonna give a speech, but that's not my job.
you're welcome to.
Nope.
Yeah.
Inappropriate.
Yeah, what plaintiff appellant is asking this court to do is to legislate. They're asking for this court to come up with a test to make this be a constructive denial when by all evidence that's been presented, the city was using its best efforts to fulfill these requests on a first in, first out sort of basis. We did talk quite at length during the circuit court oral argument about having different kind of buckets of time, because the appellant has raised the issue of this only took 3.5 hours to fulfill. Well, the city has broken it down into 2 different categories. The first being simply any request that takes less than the amount that would require a deposit. Those just get processed very quickly and routinely. So that's where the line came from. All other requests go into the queue. And as Judge Feeney pointed out, that to take somebody out of line just because they've got a simpler request, that might be argued to be arbitrary and capricious. So I don't think I have anything further, but I'm happy to answer any other questions.
Okay.
No.
Would a decision of our court imposing a deadline, would that be a violation of the Headley Amendment? So.
Yeah. What with respect, let me just ask, with respect to the reasonableness request, there, as we said, there's no similar time limit in the federal statute as in the state statute, right?
That's my understanding, but the language in the federal statute is substantially different from what is in the state statute.
Very good. So, but it's still, we're doing Macintosh and Honeycrisp, right? So as opposed to the same sort. But with respect to the reasonableness, do you think that that we have to look at that? Given the time, I'm trying to think the whole arbitrary and capricious, because that's such a high standard. That's such a high standard. So I'm not sure if that only applies to the willful withholding, or does that also apply perhaps to looking at the reasonable? It was unreasonable. I mean, there's arbitrary and capricious, how it was unreasonable that they took this long.
It can possibly get to that level, but that's not what has been alleged in this case. In this case, they have not asked for us to, or asked this court to find that we acted arbitrarily and capriciously, only that we acted unreasonably. And the appellants have asked that there be some very rebuttable presumption time limitations put in to this statute, which are not included in the actual language. And part of what they've asked for from the federal FOIA is an ask for extraordinary or temporary circumstances. That's language out of the federal FOIA statute that is not here. So if there were like the immediate influx of FOIA requests in the thousands, that would be a temporary circumstance. But that language isn't included in the state statute. So the state legislature chose to put in very strict deadlines for responding initially, but it chose not to when it comes to fulfillment, acknowledging that there's a lot of different types of FOIA requests and a lot of different types of government throughout the state.
All right, thank you. Some rebuttal?
Just briefly. I just wanted to address, the idea of a sudden inundation of requests, and the relationship to the federal FOIA, et cetera, et cetera. The court might not feel comfortable with concrete deadlines of 30 days, 90 days, whatever it may be. The point is that the legislature has spoken. They've said that the public bodies are required to provide a reasonable opportunity for access. We believe that it involves timely response. It must involve a timely disclosure. And this court is not legislating when it says what reasonable opportunity means. Courts are regularly operationalizing the concept of reasonableness. It's not something foreign or new to the court. So
But to give a specific time
to give a specific time
as to what's reasonable and what's unreasonable?
What we've done there is we've suggested that as a possible starting point, and it's not just pulled out of thin air. We've looked at cases in other states. We've looked at cases under the federal FOIA, and the 30-day sort of presumption is, we think, nicely balances that case law. We don't have any Michigan case law, unfortunately, on this. That case law and the competing interests between the pro-disclosure purpose of the statute and the practical realities of responding.
See, my problem is if the legislature wanted a specific time, they wouldn't have said reasonable. But reasonable is one of those slippery words that what's reasonable to one person is unreasonable to another. So it's a bad word in a statute like this, but that's the statute, or that's the word they chose. But 13 months is too long.
We agree, obviously. And I think it's fair to say that, what they've left us with is reasonable. This court has to determine what that means. And if you don't adopt the 30-day presumptive, date, or the 90, the sort of outside figure of 90 days presumed unreasonable, even if you don't adopt that, I think, some of the factors that we've offered for the court to consider in determining reasonableness, I think, are still valuable. And one of those is, a sudden inundation of 1,000 requests in a day. Obviously, those are extenuating circumstances. And if a public body can present, evidence that occurred, then that would certainly weigh in their favor in terms of a reasonableness analysis.
But don't you agree to Judge Kelly's position that, the legislature and the federal government also decided not to put a date certain on this ability to respond? If you get the yes or no quickly, but the fulfillment, I'll call it. Because doesn't it seem kind of obvious that they didn't want to tie their own hands? These are people who are, as Judge Redford said, they have to deal with FOIA requests all the time.
Legislature does not.
Well, you know what I mean, but they have the people who are interested in their states, everybody else.
The lobbyists in their offices.
Correct. Sorry, I need to make that clear. But, yeah, so it seems kind of presumptuous. From my old job, we had to do reasonableness all the time, and it depended completely on the circumstances. What's reasonable in one case might not be reasonable in another case.
I think that's totally fair, Your Honor. And, we're lawyers, not judges. So maybe we're a little ham-fisted with the, what's the test? I think what's most important to take away is that we need a test. We need a test here. 13 months is far too long to be considered reasonable under the statute. And and we think that the court should provide guidance to lower courts, to requesters and to public bodies on what reasonable timeline looks like. And these are the factors we're going to look at. And, the fact that you've got a backlog, is not an excuse in and of itself to allow response times to climb up beyond, a year, 2 years, 5 years. A predictable, steady increase in a backlog, I don't think is a justification for delay. And that's the sole justification we've got in this case.
Reasonable doesn't mean when we get around to it.
Right. Exactly. Exactly. Unless the court has other questions.
I think so.
Okay. Thank you
Thank you
very
very
much.
much. That case will be submitted. Item 24, docket 374789, Enray JGS Junior. Oral argument has been waived on that case, I believe.
I'm
not endorsed, but I would.
on 24.
Yeah. Yeah, well,
I don't think I.
no, I mean, appreciate you coming, but 25, docket 374401, the Tucker Pruitt Gray Miners. Ambrose,
Good afternoon.
you've been waiting
So-
here since this morning?
Well, I learned a lot.
Okay, good, not time wasted.
No, it's not.
Ready to become a FOIA attorney? Sorry.
Thankfully, you don't heat your house with oil.
Oh, my gosh. Yeah.
Yeah, Ronald Ambrose appearing on behalf of the mother in this case. I'm unopposed for oral argument, so I don't necessarily have to go through every aspect of my brief. I have provided the court with 40 pages of detail on this matter. And one of the first issue that I raise is more or less it is a procedural issue, and there is a requirement that an adjudication happen within 63 days. And my opponent says, well, there was a waiver and it occurred by the attorney. I think it was retained attorney at that time, but that was like 2 months into the case where this new attorney comes in and says he waives the adjudication. But then we get 13 months down the line, they still don't have an adjudication of the case, and the children are away from my client. So I despite this attorney's initial statement 2 months into the case, I don't think that justified 15-month delay in the adjudication. There was the second issue that I raised was mother was in I believe it's an adjoining county, Van Buren, addressing the felony warrant. And all she requested was just a brief period of time.
Does it matter that it was just I shouldn't say just, that's a poor choice of words. I apologize. Does it matter that which she was not present for was the pronouncement of the court's opinion and finding?
I made the analogy to
Sentencing. That was very insightful, I thought.
And that's why I like to appear in person. I'll do my level best, to appear before the court and make my arguments, and because I think there's a personal aspect to it. When I'm not a judge, you've been a trial court judge, and I don't know the
Wildly
history.
successful plaintiff's lawyer.
Okay. But true or not, I wouldn't know, but if you have a live person in front of you and you're, adjudicating an important
Right, it was,
aspect of their life, whether their liberty is lost or if their children are taken away from them. I think it's kind of important
Good
that
point.
they be there. And the adjournment wouldn't have been I mean, mother seemed to say, hey, just give me a couple hours. I have to take care of this. Third issue, whether or not a statutory basis was made for terminating her rights. We believe that they were not, and I outlined the reasons why in the brief. And then finally, the best interests. I mean, I think I got a little bit of a concession from my opponent on that issue, but the trial is supposed to treat each individual child separately. And there was at least one child who expressed an opinion that she wanted to go back with mom. And the trial court seems to just lump all the children together without individual.
Is that the oldest child?
I believe it was, I can't.
Okay.
It was not the twins because the twins were taken at birth. But it was the one that had some physical issues without saying his name.
Yep.
I think that was the child who was the next oldest before the twins, right?
Believe so. W is my
Yeah,
recollection.
WP, I think, yes.
Other than that, I have nothing.
Thank you.
Appreciate you showing up on these.
Yeah. Oh, and he has one more.
I do.
Oh, you do? Okay.
Well, and let me ask you too, because so much of the time, I think that we had one more, and I can't remember if it's this one or the other one. Where they held the 181-day review hearing, didn't they? Even though they were delaying on the adjudication.
Believe so, yeah.
Yes, so that's contemplated by the court rules, because lots of times we have the criminal case for the parent that we're waiting to get resolved while we're trying to go ahead and adjudicate, because the prosecutors don't want to call the kids to testify twice or whatever that it might be. And for us, it was more a problem of funding. So we'd lose the 4E status. The county have to pay for everything as opposed to the state through 4E, Title 4E. And we'd blow our guidelines, which, people in Lansing are all pepped up about. It's interesting though, because I do agree that there's due process concerns along with these things. But then you've got the parents who kidnapped the kids at visitation and they took off for Kentucky. And you can't really work a treatment plan from Kentucky. So I'm trying to figure out how to balance all that.
Not the best set of facts, I agree, but I think there was a sense of frustration on the parents' parts, which doesn't necessarily justify it. The delay in the case, and I think was the impetus for their action. Plus, mom, it seemed that she had a better opportunity at the stake for meeting not only her needs, but potentially the children.
That's all I've got.
All right, so we're on to number 26, docket number 375. By the way, 25 also had docket number 37404. We handle that too, right? The Pruitt Gray minors?
No.
Okay, so
That was
Is that last one,
father's
20?
counsel.
yeah. I'm sorry, I go to mush at this hour. Say that, are we on 26 now? The Ickes minors? Yes, okay.
Yes.
Item 26, docket 375-736, Henry Ickes minor. I apologize for that.
Ronald Ambrose here on behalf of the father. I don't think either the guardian ad litem or the petitioner in the case filed any. And I was under the impression that they would concede error on the whole case. But they did not. I think there are clear violations of my client's right in this case that I raised the two issues and I feel that
Right, because if I could ask Mr. Ambrose, the trial court said the basis was abandonment, right? Or one of the
Well,
bases.
yeah, I mean,
But he's not even the lawfully recognized as the child's father or parent until well into it. Is that right?
you're
Or am I
absolutely
remembering this
right.
completely wrong?
You're absolutely, and he expressed his desires once the,
Wasn't it something like, hey, as soon as I'm determined to be the dad, I want to be the dad, or, you know, I mean,
that's
that's a
exactly.
paraphrase, but,
Yeah, I mean, that.
and then nothing. And then, oh no, we're counting from when we gave you notice, even though there's no DNA, there's no nothing, you haven't filled out any form. And then they say, you abandoned the child.
Yeah. Yeah, and they don't bring him to the trial.
Right, he's in, and that part I think is a stickier wicket for you, because he's in Ohio, right? In custody in
Yes,
Ohio.
Yeah.
But there had been at least video in the past.
But I thought he was in jail during that time. Because the court rule talks about specifically the initial caps Department of Corrections, which is clear by the case law that means the Michigan Department of Corrections, because we had horrible time getting people either in the feds or in other states to comply, despite numerous notices and calls and everything else. So.
All right, well, but I agree with you.
So don't look at it.
So, but.
Is your guy, is he incarcerated now?
He's away from that, if I can.
Expand the record. Sorry.
He has been released to, and I want to say like a halfway house.
Timing wise, it would seem to make sense. Yeah, okay.
But
So
him and, I mean, expanding the record, him and his family have been always in contact with.
With you or with?
Yes.
Okay.
So he wants this, wants to do what he, from day one, always wanted to do is be the dad. Just confirming, like you said, that he is the.
Right. What county was this? Oh, it was along the state line. Yep. Yeah, I think you're right.
Hillsdale? Yeah.
So my question to you though is, we've got people in Ray Long, which talks about, okay, you're not supposed to look back to the point at which they're identified as a putative. And then in Ray Nip, KNIPP, which was just decided in 2024, that talks about, the plain language of 712A.19B3A2 doesn't require that the requisite 91-day period of abandonment occur after judicial determination of paternity has been made. So, because I think he acknowledged that he was probably the dad. Mom identified no one else. So I'm trying to figure out, because Ray Long seems to say, no, we do it once he qualifies as a parent under 2B6. But then Ray Nip comes and says, look, we can consider all of his actions.
And, I think Mason says even though a person, he's incarcerated, so they never even tried to give him, he was incarcerated but he has he had expressed his desire to parent, and there was no indication that he had been abandoned.
He
He wasn't there at birth, right? He wasn't there for the birth, as I recall. Okay. That's like I said, it's just interesting that the case law has developed in the way that it has, that we seem to have this conflict. So, because I had plenty of dads who we determined to be biological, but certain reading of the statutes is that, okay, then they have to file custody action, a paternity action, sign an affidavit of parentage, which establishes them as legal parent, because there's a difference between putative, biological, legal. And in this case, Judge Bell just went, bing, you're the legal dad, which I don't know any basis for doing that because there was no rope action. There was nothing that would permit him to do that. So those things combined together just give me a little bit of pause as to this. If you know what I'm saying.
I do. I just disagree that there was this aggravating circumstance. Yeah, I mean, everything in the record, according to all of his statements, were that he wanted to bother his child. As soon as he got out of, his predicament, his incarceration. Right. Appreciate it.
Okay, thank you.
Thanks.
Thank you.
Good to see you.
Mr. Ambrose. Next item is 27, docket number 376-213, and Ray Ross minor. There's been a waiver of oral argument in that case. 28 has two consolidated matters. First is 373-959, the Burkholder minor, and 374-948, Liddell Burkholder minors. Those will be submitted on the brief because nobody asked for oral argument. After that is number 29, docket number 374-527, Joseph Francis Schuler versus Martin Spring and Driveline. There's a remote request to appear, but only to answer any questions we might have from Mr. Schuler.
Is he on? Mr. Schuler, is he on? Do we know?
I'm not here.
Okay.
Looks like they're trying to get him on the. There we go. All right, good afternoon. Are you Joseph Francis Schuler?
Yes.
Okay. Schuler, we've read your brief. We're familiar with the case. You didn't properly request oral argument, so you don't,
Sorry.
but you're here if we have any questions. There's three
Yes.
judges here. I do not have any questions myself. Well, I'll see if the
Good
other
morning,
judges do.
I do not.
I don't either.
Okay, none of us have any questions, but rest assured, we've read this file and we'll try to get an opinion out within a couple weeks.
Yes, sir. Thank you, Your Honor.
Right. Thank you very much.
Thank you
Have a
very
great
much.
day.
You too.
Your case will be submitted. That brings us at long last to item number 30, last case for the day, docket number 375-182, Tiffany Janae Belzewski versus Christopher. What is that?
Lavoy.
No, I can't pronounce that middle name. Michelle Lavoy? Michael? Oh, the double L?
I think so.
Okay.
I think it's Michael as well, Your Honor. I am Daniel Bucher. I represent the appellant, Ms. Tiffany Balzeski. I gave you a 50-page brief as well as a reply brief, so I don't want to regurgitate that which I've already written and presented to the court. But I really think and the brief really encompasses all of the errors of law. We believe that the trial court, inappropriately committed here, but really the three big ones that I've come prepared to discuss here is first and foremost, the case should have never advanced to an evidentiary hearing for lack of proper cause or change in circumstances. Mr. Lavoy's original motion never requested any specific modification of the latest order. Did he want to modify custody, legal and or physical? Did he want to modify parenting time? And if so, to what? There are various burdens to be applied depending upon the requested modification. For example, those modifications that would modify an established custodial environment have a higher burden than those that do not. So it should have been denied outright there, but it was not. It was advanced.
So you're saying that's an abuse of discretion?
Yes, Your Honor.
Okay. That's a fairly high standard.
It is.
Okay.
But I believe the record, or probably a better way to say it, the lack thereof, supports that it should have been denied because there was no specific request to that effect.
Well, but again, the request, don't you think it can be general, but you have to be able to support it with evidence that there's been a significant change of circumstances or proper cause if it affects the established custodial environment?
Yes, but I don't think that Mr. Lavoy did that.
All right, but you're not saying that he has to use some special language, right? He can just say, we need to change custody. And then it's what he can provide that convinces the court, this is what we need to do. And then because you've shown your burden of proof that there's significant change of circumstances or proper cause here, then we'll send it off to the front of the court and then we'll have the hearing.
I think he needs to additionally assert what specific change he is requesting.
But what if he doesn't? He just loses then?
Yes, to go into the trial court and say, well, Your Honor, these are the facts that we have. I want you to change custody. Okay, that's a good step one, but step two needs to be, what is the specific requested modification?
Is there a court rule or a statute that requires them to make a specific request or modification?
I think the case law does support that, Your Honor.
Can you give me something more specific?
Well, for example, like I said, depending upon what the requested modification would be. For example, if a party has a certain number of overnights and they want to increase that significantly, that could potentially modify an established custodial environment, thereby raising the burden to clear and convincing evidence as opposed to a preponderance burden.
Yeah.
So, and I think we have cited that in our brief as well today.
Which, if any, parties were pro per? Which, if any, parties in the lower court were present in pro per?
At which stage, Your Honor?
You tell me.
Mr. Lavoy has always been in pro per since the initial filing of his August motion.
Okay.
Mhm.
And that's after the one that in the August one, he's saying, I want to have more parenting time. I want to be more involved. Words to this effect.
That's a question. But that's my point. What is his requested relief? It's not specifically
Right.
articulated.
So then upon receipt of that, at that time, then is your client represented?
He or she was represented at that time.
Okay,
Yes.
by you or somebody
Not
else?
by me, by a
Okay.
different office.
When did you join the case?
I joined the case about a week before the trial was set as limited scope counsel and I made a motion to adjourn the trial, which was denied.
All right. In August of what year was it, please?
2024.
Okay, so August 2024, the father says, I want something.
Yes.
Okay. Does your client reply to that request?
They did not file a written response. Her attorney appeared on the record and responded orally.
And then subsequently, the trial judge refers the matter to the front of the court.
Correct.
Front of the court comes up with a report, makes recommendations that say joint physical custody, legal custody should be with dad, and other things.
Yes.
Okay. Your client disagrees with that, right?
He objected to that, correct?
Okay. And then is that when you get involved?
Shortly thereafter, yes.
Was it erroneous for the trial court to refer the matter to the front of the court? And if so, why?
Yes, I cited the statute. I don't have it off the top of my head, but there is a statute that says that it cannot be referred to the front of the court without first showing proper cause and change in circumstances. And that's this first argument, is that showing was not there. So it could not legally have been referred to the front of the court for lack of that showing.
Okay, so before a trial judge can refer it to the front of the court, does the trial court have to have either an evidentiary hearing? What has to happen before the trial court can do that?
I don't believe the case law requires a full-blown evidentiary hearing on the threshold. The threshold, that's step one, threshold showing. There's got to be a hearing. There was a hearing here, but I don't believe it requires an evidentiary hearing, if that's your question.
Was there a hearing where the mom and dad were able to appear?
Yes.
And after that hearing, the trial court said, I'm sending it to front of the court.
Yes.
What was deficient in the hearing which made it an error of reversible magnitude for the trial court to send it to the FOC?
Again, I think it goes back to the proper cause change in circumstances threshold and the lack of showing thereof. If you read Mr. Lavoie's motion and the statement said at the hearing we're talking about, it doesn't read like a modification request. It really reads like an enforcement request to say, Your Honor, these are the issues that are not being complied with in the order. I want them complied with. It reads more like an enforcement request than a
Okay,
modification.
so why
request.
can't the trial court engage the assistance of the friend of the court in that process?
Well, it can, presuming there's proper cause change in circumstances for modification.
And
Oh, okay.
the court found that though.
Yes, it did.
The court found that there was changed circumstance. Okay.
Yes. And in the Kent County Standard Order, I think that's like the first line. The court has found proper cause change in circumstances to refer it to Kent County in front of the court.
Okay.
Yes.
And our review of that assessment is abuse of discretion.
Yes, I believe so.
Okay. All right. So it then comes back from FOC. FOC makes the recommendations and conclusions that your client disagrees with. And what happens?
And then I appear, she fires her old attorney, I appear limited scope to try to get a little bit of extra time to get up to speed. The request for adjournment is denied. In the hearing, the trial is the next week. They have the hearing, both in pro parties appear. That kind of brings me to my next big issue of error here, which was my client wasn't allowed to call any witnesses. She was not allowed to present any of the hundreds of documents, potential exhibits that she had read.
Before that hearing started, the father, pro per, submits at least 22 pages of exhibits, as well as what's purported to be a trial brief, handwritten, but it's in the court file. But your client doesn't submit anything.
Correct.
Why was it error for the trial court not to allow the evidence proffered by your client?
Well, I think that's a two-pronged question, both witnesses and exhibits.
Okay.
Right? So
address it however.
Yeah,
you
sure.
choose.
Well, on the witnesses, first and foremost, there was no written order obligating any witness disclosure by anybody, no witness list obligation. A lot of times there is, but in this case, there was not.
Do you think the 2022 case scheduling order before the consent agreement was entered into required nomination of witnesses and identification of exhibits?
Not familiar with that specific order, but a pre-judgment scheduling order, no, I don't think that would apply to
Okay,
post-judgment
so
proceedings.
all right. So your position is even if it's there and the case file is literally on my desk downstairs, I can't give testimony, but I think there's something in there.
Sure.
But your position is, doesn't matter, Judge. That was before the consent judgment was entered. There's no subsequent scheduling order. My guy didn't have to do this, or my client didn't have to do that.
I would presume, yes, because I'm presuming what that scheduling order says is, okay, identify witnesses 30 days before
Yeah.
the trial, the
I don't have
standard
it
language to
memorized,
that
but yeah,
effect.
it's pretty.
Yeah, but because, I mean, we don't have.
So since there isn't, after the trial court sets the hearing, you ask for adjournment, it's not given,
Yes,
and then you do not appear
Correct.
at the trial. Trial court does not allow witnesses.
and let me be clear on that. The trial court did say she would allow teachers, medical providers, what I think was termed, I don't have a transcript in front of me, but third-party non-interested type witnesses. She would not allow my client to call the witnesses she had in the courtroom, which I think consisted of her family and some friends, members of the community that she intended to offer testimony. And the trial court ended up using, like, I think the best example is the trial court stated in its ruling that, well, I'm considering the grandparents' actions here to be a hindrance to the parenting time. But she disallowed the grandparents from testifying to get their version of whatever dispute was going on regarding those set of facts. So I think that's a big error here, is that, the friend of the court individual was called on the court's own motion. Mr. Lavoie had the opportunity to call witnesses. He didn't, he just testified. And then my client had all these witnesses ready to go in there, but they were not allowed to testify.
Did she testify?
Yes.
Okay.
Yes, she did.
But the court took an offer of proof that they would all say things in support of her.
Yes.
Okay.
And the court took that. She didn't allow, if my improper client would be able to do that, she didn't allow the opportunity to allow my client to do it.
But this court also stated in the opinion, the bench opinion, that had handled this case through the entire fruition of everything from the beginning of the filing, I think, which was in 2021 originally. And numerous, I think there were at least 6 CPS cases, none of which were substantiated. And then I think there were like 8 PPOs, which also went to the same judge because it's a one judge, one family. So this judge wasn't like they were just operating in a vacuum. They had years of experience with the family.
Yes, that is correct. But that's also on the exhibit side of things. Sorry, switching gears a
Okay.
little bit
Go ahead.
there is, I mean, it's, and I think Mr. Lavoie has admitted in his briefing, the trial court did consider documents not admitted into evidence. All these many CPS reports, not a single one was offered into evidence. Statements from school officials, nothing offered into evidence. Mr. Lavoie has briefed, well, I attached them to my trial brief, therefore the court can consider them. Well, okay, that makes them a part of the court's file. Doesn't necessarily mean they're admissible at trial. Why we go to law school, learn the rules of evidence, there's procedures, we all know that.
But again, your client had peppered the file with repeated documents, almost the same documents I believe I saw at least 2 or 3 times. The same photos, the same highlighting, the same these reports, these emails with notes all over them. And I think that the friend of the court responded that your client also submitted between 800 and 1,000 pieces of paper for the friend of the court to consider to use for their investigation and things like that.
Yes,
And I know they weren't attached to the friend of the court report recommendation,
correct.
but they were considered, discussed in the friend of the court report, and like I said, and in the file. When she would file her motion, she would attach many pages of things.
Yes,
So
yes, she did.
What do you think? What remedy do you seek?
Well, first and foremost, a reversal. Our primary argument is the initial motion should not have been advanced. Reverse it and have the motion instructed to be denied. If not that, we've requested a new hearing. Allow me to call the witnesses that were disallowed. Allow me to present the exhibits that were disallowed.
So vacate the decision of whatever the date was it was issued and remand for a new hearing with notice to the parties of witnesses and exhibits and the procedure by which the trial will be conducted.
Yes, and I think a specific requirement that we're going to file witness lists, exhibits lists, and just so there's no ambiguity, because clearly somehow there was here. I think that would clear things up.
but I think that Judge Redford brought up the fact that Mr. Lavoie filed his trial brief and listed the exhibits and attached them.
Yes,
Did not, interestingly, I don't think though, Judge, I don't think he listed any witnesses.
He did, no, he did not, but he listed exhibits.
Yeah. So how do we, if the pro se Mr. Lavoie knew to do that, I mean, how,
there was no order requiring either one of them to do that. Good on him for doing it, I guess is my response.
hold it
But-
against Mike?
Well, that's what I mean is, well, how would my client know? Maybe her previous attorney told her, advised her, I don't know. But there wasn't an order from the court saying you need to file XYZ by a certain period of time. So she didn't. And then she came to trial with all these witnesses and exhibits and can't present any of that because you didn't file the documents.
There's something in the record of a colloquy between your client and the trial court of, did your client, I think, asked, or either makes a statement or asked, did you get my exhibits? And the
Right.
trial court says something like, yes.
That was at a different hearing. An intermediary hearing, I think regarding an issue regarding the child's medical care that was brought either by an ex parte motion or maybe on the court's own motion. I don't specifically recall. But yes, I noted that even in my brief because I saw it too. I don't know what it's referring to. I'd have to expand the record to give that information. But there is an interesting colloquy between Ms. Balzeski herself, even though she was represented, and the trial judge saying, did you get my evidence? Yes, I did.
Right. That I found that. I didn't understand it exactly, but
Well, because the trial judge then talks about the fact, well, did you submit it through the clerk's office? Because then I
Right.
think that's how it ends up in the file.
yes.
So I think that's what, at least that's what I took it as going for.
Okay.
I think what you're referring to, Judge, is then the judge's ruling on the morning of trial or the afternoon, at the beginning of trial,
Yes.
that afternoon when she's trying to present evidence. Well, did you file any of this? No, I did not file any of this. And actually, there's a court rule that says we're not supposed to file exhibits.
But it's clear that your client has. And
Sure.
and he has too. I mean,
Yes.
it's full.
Yes.
But
the exhibit specific for this trial is the issue.
and so are you saying that the exhibits, well, that's expanding the record. I'm not going to go there.
Right.
Okay, so my question to you, it is in the record, it is clear that both of these parents engage in what could be deemed less than appropriate behavior by videotaping both of them, videotaping each other during the child exchange.
Okay.
They disagree regarding evaluations. I think they both agree that he has issues. But legal custody has to do with the ability to make decisions together, important decisions for the child, medical, surgical, school, discipline. I call it the meat and potatoes of parenting, right? And when two parents cannot agree and cannot talk to each other regarding those important issues, that's when the court is faced with the loving and difficult decision based upon the law and all the factors to consider under MCL 722.23 and the parenting time factors under subsection 26 to determine that only one parent should have legal custody because these two people cannot agree. And based upon the evidence, the testimony by the front of the court, your client's statements to medical providers about Mr. Lavoie and activities that she claimed he engaged in or didn't engage in. You're saying that the court's determination with respect to sole legal custody was inappropriate?
Yes, absolutely. We do not believe that ruling was in the best interest of the minor child.
Because it wasn't given to mom.
We had not made that request. Well, they had, I was not attorney at the time, but there was no motion brought by her to give her sole legal. She was simply defending the motion filed by Mr. Lavoie.
Okay, but you understand when the motion is filed to ask for a change of custody or custody to be evaluated, all of it can be evaluated, not
Yes,
just
I
part of it.
Sorry. Yes.
Okay, so is it? I saw no testimony, and perhaps you can correct me on this. There was no testimony in the record that your client, said that she could co-parent with Mr. Lavoie. Is that correct?
I believe that is incorrect. I've cited that under one of the best interest factors in our brief that both parties testified that they were willing and able to co-parent with one another. Both of them said that.
So how does that square with her telling the front of the court individual that she wants to remove Mr. Lavoie completely from the child's life?
That was in the testimony you're saying from the front of the court
That's
representative.
what I believe, I recall.
I think that's one of the main issues here is that this front of the court representative was allowed to be called in and essentially read her report, which I think is abnormal in and of itself. The report itself is inadmissible absent stipulation from the parties.
But under MRA 1101, sub 9, is it?
The court may consider it.
Correct.
Yes. Yes, the court may consider it, but may not rely upon it for its underlying ruling, is my understanding.
But again, and the court had this 3 years of lots of activity. I mean, we tend to have like 5% of the cases take up 95% of our time, right? Because a lot of the cases just settle resolve, especially in domestic relations. This is obviously a case that the judge saw a lot,
I agree.
so.
Otherwise, I think my trial brief fully addresses the issues. Any other questions that I can assist with?
Yep.
Thank you very
Thank you
much.
very much.
Yes.
She's been on the case the whole time.
I wish I had been. Truthfully, I wish I had
I
been.
think
Thank you.
probably been very helpful for the trial court.
We are voting and adjourned.